Sister, you're there?
Yes, yes, yes. Lordship.
In view of the aforesaid submissions, we are of the considered opinion that the conviction be made not under section 300 of the IPC and would come under section 299 pertaining to culpable homicide not amounting to murder. As such, we are of the view that the sentence is required to be altered to be under section 304 part 2 of the IPC. We accordingly alter the sentence to one of rigorous imprisonment for 7 years. Send back the TCR. We have recorded our appreciation for the assistance rendered by the learned amicus curiae.
Okay. Lordship, it was last.
Press matter.
No, Lordship, it was already admitted, Lordship, IAS pending, and it was last posted on 1/10/2024, Lordship. Thereafter, no.
Paper book prepared.
No, Lordship.
When do you want?
Next week, any date, Lordship. Similar fare and criminal appeal 445/24, Lordship. It was same, Lordship. It was last
Admitted.
listed on- Lordship, admitted, Lordship. IAS pending and
The
LCR.
conviction is under what what sections?
POCSO, Lordship.
Both.
Lordship, both.
Private respondent served.
Earlier occasion, Lordship, notice was issued, Lordship.
Okay, we'll see next week.
Deeply obliged.
Yes, madam.
May I please your lordship, with the consent of the other side,
Yes.
item number 14, my lord, kindly adjourn the matter.
1-4.
Yes, my
This matter was adjourned on earlier occasions also. Why? Why are you seeking time?
my senior engaged counsel, R.P. Sharma sir, due to some difficulty.
You've informed the learned counsel for the private respondent.
I
B.
think-
Prasad. You have to inform him. Do not make a mention without informing. Don't make a mention. Inform him, we'll adjourn the matter. But after informing. Yes,
Please, your lordship, I beg to mention for listing of a criminal appeal, my lord.
press matter.
No, my lord, 23 matter. Lord, next week, any day, my
What is the stage?
lord, the paper book is already ready, my lord. And it's conviction
Paper
under
books-
section 6.
Paper book served upon you.
Yes, my lord.
Okay, next week.
Much obliged.
May I please, Your Lord? And the paper listing of a appeal, it was admitted on 18/12. Thereafter, it has not been listed, Lordship. I is also pending.
Okay.
Any date, Lordship?
When was it admitted?
18/12/2020,
Next week.
next week, obliged.
We've got many officers. Why are you in the court?
IPS, young IPS,
They
probation.
come for training there, sir.
Okay. Hope you have a good experience and learning experience. Okay. Yes.
One to six.
His short might have.
My is very short.
You want an ossification?
Yes,
Yes, madam.
I've seen the orders. There the certificates were not given.
yes, but
Because it didn't
certificate,
tally with.
yeah, doesn't tally with the record. They could not find in the record. So only option is left with regard to this 29 is ossification test. And my learned colleague has clearly submitted on the occasion that only alternative is ossification.
Because under section 94,
Yes.
95, there are
94,
three,
94.
94.
there are three steps.
Can we have that act?
Juvenile justice. Sir.
First, you need to have the birth certificate. If
Yeah.
not
Then-
the school certificate,
Huh.
then the ossification.
Yeah.
test.
Yeah,
He is trying to make out a case that the certificates are not conclusive.
Yes. this
conclusive,
is
yeah.
what. But whether both the certificates were concerned, were considered.
He didn't
I
go
am
to
not-
school, so there is no question of school
School.
certificate.
Acha.
A certificate was been produced, my lord. According to the records, my lord, as per the inquiry report, as per the officers of this authority, this certificate, they could not find out any traces with regard to these records. 94-3, my lord. 1, 2, my lord, 2, 3, my lord.
Yes. You are referring to the Act of 2015.
Yes, ma'am.
You're in which matter, Mr. Bhuya?
It's three, my lord, three.
And Lordship can see the orders also where the session judge
Three
has,
is,
Enquiry report,
these are in the form of orders I've seen.
most part.
It is the
It
form
is
of,
in the IA.
it is in the eye, it is marked as something. I checked it last time.
The juvenility issue was one of the issues in the trial.
Yes, although it's been in the judgment, it has been reflected, it's not been taken. But in 313 statement, he has.
No, was it an issue? Was it answered?
No,
Not answered.
No. So 29 will come, my lord, this section 7A will come into, it can be taken at.
No, you
least-
can take it at
Yeah,
any stage.
yeah. That
That is not a difficulty.
mine.
But there is no conclusive finding on the
No,
age
no,
of the victim.
no.
Which is the concerned learned judge?
My
Which
lord,
court?
that is, my lord,
Session judge.
session judge, my lord,
Vilasipara.
Bilasipara, yes.
Additional session judge Vilasipara. Or session.
As of seventh day, the date, the age would be determined. So we can get. No, no. Today is the certification exam. Today is the date of birth, roundabout age. Heard Sri A.K. Bhuya Learned Counsel for the applicant. Also heard Ms. S. Jahan Learned APP Assam, para. The connected appeal was admitted on 7/8/2023. And the records were also called for. Para. Subsequently, the present IA has been filed praying for suspension of the sentence on the primary ground that the applicant was a juvenile at the time of commission of the offense. This court had accordingly passed an order on 14/8/2024 calling for a report from the concerned additional session judge Bilasipara. When this matter had come up for consideration on 4/4/2025, the following order was passed. 4/4, okay. Para. Sri Bhuya, the learned counsel for the applicant, has drawn the attention of this court to section 94 of the Juvenile Justice Care and Protection of Children Act 2015 with regard to the presumption and determination of age. He has submitted that the aforesaid provision would come into play for determining the age of a victim of an offense under the POCSO Act. Full stop. He has submitted that the victim did not attend any school and therefore there was no certificates from the school. And further, there was no birth certificate of the victim, which was produced and proved in the trial, and therefore the only test left for determining the age is an ossification test as provided under subsection and under 94(2)(3). Full stop. Para. Miss Jahan, the learned APP, has by referring to the earlier order passed on 4/4/2025, has submitted that on the said date she had already made her position clear that an ossification test would be may be necessary for the interest of justice. Para. For ready reference, comma, section 94 of the So-and-so Act is extracted herein below. Para. As would appear from the record that the first two alternatives under subsection 2 are not available for determining the age, and therefore the only option left is to conduct an ossification test for determining the age of the victim, which has not been done. Full stop. Though under section 29 of the POCSO Act, there is a presumption. The said presumption would come into play only when the foundational facts are established by the prosecution in the trial. And for that, determination of the age would be one of the primary ingredients. Para. In view of the above, and in the interest of justice, we direct conducting of an ossification test of the victim, which victim
By the
accordingly.
applicant, of the applicant. ma'am. It's a 302 case.
Yes, applicant,
Hassan Ali, no?
of the applicant.
Applicant.
Name is Hassan Ali.
Not the victim, applicant. Accordingly,
And the POCSO Act, my lord, 302.
accordingly, a direction to that respect is passed. Full stop. The records in original are to be remanded back to the concerned court, namely the learned court of the additional session judge, Vilasipara, by the registry of this court expeditiously. Full stop. The said test be conducted accordingly, and the report thereof be transmitted back to this court through the registry within a period of.
Earlier, it was 1 month under the earlier act. Now
It-
that bar is that
15
requirement
days.
is not there.
As a 15 days.
On 15
It,
days.
provided he is conduct
No,
the
no, no,
order
that is for the
shall
test.
be
Now this records will go
completed
back.
within 15 days.
Records will go back. We have to
Yes.
be reasonable.
It
Not
will take
15 days
time.
may not be enough.
Yes.
Within a month,
Within a month.
within a month.
Okay.
Order to victim, huh? Victim to the applicant of, huh?
And the POCSO Act, my lord, it's 302, my lord.
Doctor has dictated POCSO.
POCSO, my lord.
Okay,
It will be
okay,
my
302, it's POCSO is not. okay.
my lord. Deeply obliged.
Then foundation, the aspect of foundational facts will not come.
Not come. His is
Okay,
the
okay.
paramount.
We were under the impression it is under the POCSO Act.
No,
Okay, we'll make the necessary
Yeah.
corrections.
But that is under my section, item 3, my lord.
Okay,
My item is 1 and 5, my.
okay, what is your case?
My case is, I have, come for bail, my,
Bail.
the same case, my lord.
No, under what, are you arguing on merits?
Yeah, merit means, my, I have also merit as well as the length of detention, my lord. Length of detention means, my lord, about
No,
2 years.
paper book is ready. We'll
No, it is
get
ready, my, it came several times for my lord hearing. Normally, my lord.
We'll give you a fixed date.
No, my lord, fixed date also even come sometime, my lord, because so
See, we
series of
cannot
the,
help. Every day we are hearing matters.
so many advocates are there, my lord, somebody got some difficulties, some other way. It is
You-
coming
you-
several times, your from office to.
You sort out your problems, we'll give you a date of hearing.
No, date, but it was in the,
2023.
no, last day, it was in the hearing days. Your lordship passed an order to come.
No, understood, but it was passed only to facilitate this court to pass an order under ossification test. That's a different issue.
No, that is, but at the same time, I praise my lord that instead of hearing, madam, my matter may also be taken.
On
forward.
merits, if you argue, we can, but we think that instead of giving you time in the IA, we hear the matter appeal, we give you a
But if
fixed
your
date.
lordship find my lord, on the, my lord, in the preliminary,
Length of detention, since when are you in the custody?
28/6/23.
23.
A case matter, no single matter, one day the person who was alleged to be eyewitness, he said he has not seen. Nothing matter, general allegation, and 2 persons coming from jail, they have deposed against us, madam. And their family members. This is the case, madam.
You may have a good case on merits, you argue on merits.
If for losses, I am ready, madam, otherwise, but only series of the cases are there.
No,
madam.
why serious? You can argue your own case.
Yes, yes, madam, I can agree, madam.
Day after tomorrow you argue,
Yeah, tomorrow,
tomorrow is a holiday,
Thursday.
he'll be prepared.
Because here so many accused are involved and we'll
No,
love.
we'll hear Mr. Chaudhary's appeal.
He is appearing for 4, I think.
Yes,
Some-
yes, three, madam, item 1 and 5. Item 1,
See,
3 person, 5 1 person, madam.
See, accused in a criminal case, we do not know what materials are there
Hmm.
so far as each of the accused are
Hmm.
concerned. If he thinks that he has a good case, he can argue.
Yeah.
Day after
149
tomorrow?
is there, Lordship, 149 is there, common object.
That common
That,
object, that also not been, especially role has not been attributed to anyone, general, except 2 or 3 persons, my lord, one already died.
Is it required under 149?
Yes, 149, your
Why-
lordship.
where- let us see
A
149.
specific PA, my lord, your
Let us see
lordship,
149.
I have given my lord, your lordship kindly, look to this one. But just you have to kindly say, my lord, note.
Let us see the statute, let us see 149, what is 149?
Just I have given my lord a note, my lord,
No, note is okay, what is 149?
yes. 49. Well, page 8 of my note also, it is 149 is quoted. me.
No, no, you.
Yes. Yes, madam. Every member of, your lordship got the book.
Yes.
Every member of unlawful assembly guilty of offence committed in prosecution of common object. If an offence is committed by any member of an assembly in prosecution of the common object of that assembly,
Mm.
or such as members of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of committing of that offence is a member of the said assembly is guilty of that offence.
It's here.
Now you will kindly see the Supreme Court's, just my, I have given in my note, page 8, my.
No, no,
Yes.
we'll consider in details, what is your take?
Yes,
What do you
my
say?
case is my lord, the Supreme Court, just my, I'm getting with. The above, it makes clear, Supreme Court saying, convicting accused with 8 of 59, the court must give clear finding regarding nature of common object and that the object was unlawful. In absence of such finding as also any override, or on the part of the accused persons, mere fact that they were armed would not be sufficient to prove common object. Section 149 creates a specific offence and deals with punishment of that offence. Whenever the court convicts any person or person of an offence with the aid of 149, a clear finding regarding the common object of the assembly must be given. And the evidence discussed must show not only the nature of the common object, but also that the object was unlawful. Before recording a conviction under section 149, essential ingredients of section 141 must be established. The above principle have been reiterated in Buddha Mandal case of Bihar and so on and so
See,
forth.
there are decisions, many decisions.
Yes, many decisions.
But 141 and 149, the only connection is an unlawful assembly. Beyond that, there is no connection.
No, my lord.
141 is itself punishable.
Yes,
149 is not itself
Yes,
punishable.
it is a
149
special offence,
Connected with a specific
that's
offence.
true. That's true.
There
my-
is a huge difference. It may
That's
come
true.
under chapter 8.
But the,
But see the language of 141.
yes, No, language interpreted by the Supreme Court.
No,
my
no,
lord.
can I kindly see the language of the
Yes.
statute? Let us
So
go by
each,
statute.
every person who at the time of committing that offense is a member of the same assembly.
Same, what are the offense?
Yeah. Offense 302,
No, not 149.
Oh, 141.
There are five
141.
offenses.
141.
141.
141.
There are five offenses.
141, an assembly of 5 or more person is designated unlawful assembly.
Yes,
So
then.
here says, my
no,
lord,
Then, can
If
you
the
read?
common object.
Can you read?
assembly, if the common object of the person composing that the assembly is to about, that I understand, your lordship.
141 is itself punishable.
Yes, yes, my lord.
149 is not
Yes,
punishable.
it is.
It has to be
expression.
connected with
Yes,
an
my sir,
offense.
it is an offense. It's a
The
right.
only connection with 141 is to have an unlawful assembly of
That-
5 or more
That's
persons.
true. Whoever unlawful assembly is there.
Other than that, there is no connection.
So that has not been proved, my lord, whether these persons were in the assembly or not, my lord.
We'll
That is
see-
not my
we'll
case.
see day after tomorrow.
Finding is there,
Day after tomorrow.
Lord, finding is there by the learned trial court.
Day after tomorrow for hearing.
Yes, it-
Where is the paper book?
Paperwork is there, my lord.
number of volume,
2 volumes, my lord.
2 volume.
How many witnesses?
20.
20.
Basically, 5 witnesses relied upon. Relied on.
Who are your colleagues in the other appeal?
Mr. A.M. Baga is there.
Okay.
Mr. Anandabuya, his case already.
Okay,
madam.
his case is.
And Soja, I am there, madam, in the case, madam.
Okay.
And
Then- Okay, day
He's
after
also-
tomorrow.
My
we'll-
eye is also there, my lord, on medical ground. Because he is 75 years. Already 48 bench has granted bail. Because-
You are on bail.
No, another accused has been granted bail.
So day after tomorrow, we'll try to finish off the appeal.
Or I can bring the medical report from the jail. If he
He
is,
was suffering from illness, my lord, that on the ground of illness
Mr.
already.
Kotoki's case will be different.
Huh.
He's seeking bail on medical ground. Mr. Chaudhary is trying to argue a case on merits.
Yes.
We'll consider on merits. If you want to argue your case on day after tomorrow, you're.
now one request, madam, juvenile your lordship is directed to record or to be sent, my lord. It is also,
oh, the records. will have-
Amir, we will send a scan copy of the record.
Oh, Lord.
We'll retain the original report. Scan copy.
even with us, like,
But again, whether lordship will segregate and hear few accused and then again later few.
No, his case will be on a juvenility.
And but Bora's case is there on merit and Sahed Ali and all.
We'll
Three person.
see, this way, the matter will cannot, the appeals will never be heard.
Yes. we'll
Somebody
have-
has to make a, we'll try day after tomorrow. Okay. Heard,
Oh,
কোনো
yeah.
problem আছে নাকি?
heard.
Hmm.
Sri H.R.A. Chaudhary, Learned Senior Counsel for the appellant and Baki Villages, in Swinson, R. Kotokis. And that's for which matter?
Item 1,
Please give the names in a list.
item 1 and 5, my,
Also heard.
1 and
Ms.
5.
S.
1 and 5.
Jahan, Learned APP, Assam. Footstep. Do the Learned Council had pressed the I, we are of the opinion that in this series of matters, so far as I number is concerned, a separate order has been passed today for an ossification test. And the said appeal be listed separately, absolutely, no? Though the Learned Council has pressed the IA, we are of the opinion that since the paper book has been prepared, the appeals itself, or appeals can be heard. Clara? List for hearing on Thursday.
Or it can be on Monday also next. Because
Monday is a
tomorrow is
holiday.
again- Oh, Monday is a holiday. Tuesday,
Monday is holiday.
and they are
Monday,
also, they also
Monday.
want it.
Tuesday, madam.
As your lordship, my lord.
No, I'm leaving up to you. You express urgency, we are in pre-hearing.
Other friends are saying, my lord,
See, again tomorrow you will say,
no, my lord.
court is not hearing.
No, my lord, I am ready, my lord. I am other is ready, my lord. If they are my lord, because all are together, my lord. I am ready, my lord. I even
Okay,
today also I
yeah.
am ready.
No, today, madam, may not be in.
Yes, my lord.
I'll have to see.
20 witnesses.
Tuesday.
Okay, Tuesday then.
Tuesday.
Tuesday for sure.
Tuesday.
Tuesday, tarik, timan tarik,
Tuesday,
1-3.
1-6.
So far, the item number 6, my lord, that is I, my lord, that is on medical ground. Because coordinate bench has granted bail, my. What is the-
Tuesday will take up your matter.
Because already, considering the fact he was 70.
What is the medical ground?
Medical mind, because your lordship will find there's a judgment, same, similar accused was granted bail.
No, no, what is your ground?
He was suffering from hydrophilisis, fine.
Huh?
There's the problem with, because the medical, I have got a report from the Dhubri Medical College, fine.
Report is of which date?
It is of, he was, while he was admitted, my lord, while he was on jail in 2023, my lord.
23. What is the present stage?
Present stage, I cannot say because.
They have to.
Let it be heard on merits if we get
Well,
acquittal,
in
then.
fact, this court, my lord, Podinate went on 4/4/2005, co-accused, co-appellant was granted bail.
No, see, medical grounds cannot be at par. It has to be, you have to make out a case. on
I
the-
understand, but since
Somebody has been on medical ground, I have been, what is your ailment? Tell us.
that he's saying Bob, that there's the
Are you given treatment in the jail or not?
that presently I cannot say, my lord.
Then
But considering
get the
the,
instructions.
but considering the
If you
age, my
think
lord,
there is a serious
Big-
issue.
but
you
considering the age, my
address
lord,
the Court will direct madam to have a report.
But Monday I can get the report.
You try to
But-
get a report.
because here says, my lord, he's 75 years and suffering from mental illness and bail was granted.
This is the instruction of 2023.
When co-appellant has been granted bail.
No, what is your ailment?
Ailment, my lord, suffering from,
When?
because from the year from 23, I found that he was suffering from constipation,
I'll get the report.
dyspepsia, all age, all ailment, my lord,
I'll get,
because over 75 years of age.
on Monday I'll get the report.
Oh, insofar as so and so is concerned, as bail has been, as suspension of the sentence and grant of bail has
Do-
been,
do
sought
you
for-
only?
has been prayed for on medical grounds. The learned APP Assam shall obtain a medical report on
From
the,
Which jail I am.
Dhubri jail, my lord, it was,
regarding the said applicant. Give her the details.
yes,
If it
Okay.
to be perhaps as a jail.
Oh, no, Monday, no. Tuesday, I collect.
it's Monday's to.
Tuesday.
Tuesday,
I
sir.
collect.
Tuesday. Okay.
If your lordship permits me, with regard to item number 14, a mention was made in the morning.
Yes, we did not allow because you were
Ma-
not there.
I was in another court in
Yeah,
that matter.
okay,
But in this matter, I was called by the registry yesterday to serve the paper book.
okay.
So
No,
I'm-
they were seeking time. Since you were not informed, we did not allow.
Right.
Where is the council? You are the council. What item number?
40
Okay.
in the supplement.
A prayer for adjournment has been sought for on behalf of the appellant. Also heard Miss Ad Jahan Leonard, APP Assam. Whereas Sri B. Prasad Leonard, council, Leonard amicus curiae is present for the respondent number 2.
Yes, sir. If your
Paper book
lordship
has been
permits me, I
served.
can take the paper. from the-
Paper book has been served on the learned counsel for the parties. Para, please for hearing after 2 weeks.
Apply.
Yes.
I didn't have the something is.
Call it to me. Yesterday's matter, madam.
So my lord, before lordship go to my lord, I have another item 12, my lord. It has come for hearing. Can it be accommodated for today only, madam, day after tomorrow, if possible? Item 12, my lord. Obliged.
You have to tomorrow. You assign work with you. Tomorrow, next week before you, next week for you. Yes. Madam Begum will be there. Who's?
I have taken one judgment regarding lordship, medical lordship, that the all the accused has been acquittal on the ground that there is no such medical report that they are having some poison or internal injuries are there, Lordship. Regarding that, have taken one citation, Lordship.
No, that is okay. What are your submissions first?
Lordship, regarding dying declaration, Lordship, there is a corroboration, Lordship. Not only one, Lordship.
You are supporting the appellant or you are supporting the judgment?
I am supporting the appellant,
You think that there are materials for conviction?
Lordship.
Okay, highlight those materials.
There are lot. Because the person who have given the dying declaration about the accused, Lordship,
Deceased.
no,
Okay.
no one is Lordship, his relative, Lordship. They are the village people, Lordship. And no one have such interest to have or enmity, Lordship, with the accused, Lordship, of giving a false statement, Lordship.
Who are the PWs who had deposed that the deceased before his death
Lord.
had given dying declaration?
Lordship. Uh, PW2, Lordship.
PW2.
PW. All the not in serial number, Lordship. All it is that.
PW2 is Nirupama Das,
Lordship.
the neighbor.
Lordship.
Where has he said? Which page? Her deposition starts at 25.
25, Lordship. Where is sub- I know the accused
Which
person.
page?
Page number 25, Lordship.
Yes.
I know the accused persons. 3 accused persons are absent today. I know them too. I knew deceased Pankaj Das, alias Boga.
No,
I'll skip this also.
you come to the portion of dying
Lordship,
declaration.
Lordship. Lordship, page 26, Lordship.
Yes,
Third line, Lordship.
yes.
I saw accused person inside have seen accused Manoj and Arup in the court. No. So it's, the accused person were threatening him that they would kill him. I offered resistance, whereupon Manoj
This
das
is not dying declaration. Where is the dying declaration?
dying. Yes.
Yeah,
Better point of.
you also said something else there. That's all. That's the only thing.
Lordship, sorry, Lordship. PW4, Lordship. Page number 31, Lordship.
31. No, here you cannot read page 31. You have to read page 33. This D Deca was re-examined, was examined after the de novo trial. Page 33. There is a
Lordship,
statement.
page number 33, Lordship. Line, Lordship,
Last line. Last
From
line, last
Lordship.
line. Last line.
Pankaj stated before me the name of the accused person. Kandarpa Das Manoj Arup, person assaulted him. Pankaj told that accused person, with the help of handkerchief, they spread a liquid on his face and eyes.
But will this be enough? Is this the cause of death?
Lordship,
Medical evidence is otherwise. There is no connection of the liquid with the cause of death.
otherwise, Lordship, in medical also there is some lacuna, Lordship. They have in postmortem they have not examined the brain and spinal, Lordship, and in
Now that coming from you will not help.
Lordship, he was immediately.
You are the PP. If your prosecution has failed, the investigation has failed in something, you cannot help.
Lordship, so that they will start, Lordship. Let them start. I will continue with my Lordship. I'll just take out the
No, madam, it's your responsibility first.
Lordship.
We'll
Then
go to
Lordship,
them.
Lordship.
Their role is very minimal.
Lordship, in the PM report also in page 180, Lordship.
180.
180, Lordship.
Yes, what is there?
Lordship, there is a both lungs congested. One on section, fourthly, liquid blood comes out.
Yes, what does
No any disease or injury seen. It is fact that no any because Lordship, blood without something, Lordship. Blood or there is Lordship report. There is a saying only with section 4 liquid blood comes out, Lordship.
Yes.
So what
40 liquid blood comes out. What does it indicate?
Lordship, without some internal injuries, Lordship.
Now you have to make out a case. There was some medical jurisprudence that this indicates an internal injury. The doctor says no disease or injury is sin.
There are some in the PM Lordship, there is something but not clear. It is also fact that Lordship in page 188, 181 also, walls healthy mucus, congested, patchy hemorrhage present on mucus. Right place contains 75 gram substance having pungent smell. There is also something, but
Madam, for this reason, the viceroy was sent for forensic test.
FSL.
FSL has given
Negative test.
a
for
negative
poison.
test for poison. So
Poison.
what else remains?
But Lordship, the person, the dying declaration also there is the immediately Lordship, the one who came near him, Lordship.
No, see, the question of dying declaration will be relevant when the cause by which the death has occurred is established in the prosecution, in the trial. Now you say he died out of poisoning. You suspect. The report is that there is no poison. There is no assault. There is no injuries found on the body.
Regarding this Lordship, Lordship, the dying declaration, Lordship, on the other side, there is a corroboration, Lordship. Because Lordship, in the dying declaration part, Lordship, page number, Lordship, Lordship, here, give me, in line Lordship,
Page,
page number 33, Lordship.
yes.
I saw one bottle, page, line Lordship, second paragraph Lordship.
Hmm.
I saw one bottle to be containing poison with smell and one handkerchief near Pankaj was crying Morilu Morilu.
Hmm.
I asked him how he came, then so and so Lordship, Pankaj told that the accused brought him from Guwahati. It is the fact that they have kidnapped him, Lord. The accused kidnapped him, that is their Lord. And the defense have not denied that fact, Lord.
What is the charge? Is the charge of kidnapping?
No, Lordship, but Lordship, after that Lordship,
No,
They-
why didn't you get the contents of the bottle examined?
that is the lacuna of Lordship. That
Why
is
did,
the-
why wasn't the bottle
that-
seized in accordance
That
with
is
law?
there for that only,
Get the
Lordship.
contents examined.
That is not
You never,
examined,
you
bottle
never
is
send
not,
the bottle or its contents for forensic test.
that there is there, Lordship, that, for that
And
Lordship.
in fact, the seizure itself is doubtful. One says that I took the bottle, one says that I gave it to the VDP. When was it seized?
But Lordship, he was first brought to international hospital, then he was sent for postmortem. In that case also, Lordship, he died there. Earlier, he was admitted in Nalbari, Lord. He has spent there one night, Lord. Then in the next day, he was sent for Guwahati, Lordship.
No, not like that. He did not spend the night there. See, this
Case
Ajahar was,
number,
no, this Ajahar was lost on 10/3/2002 at 2:30 PM afternoon.
Lord.
And the incident had happened on the previous evening.
Lord.
So after the incident, he was first taken to the Nalbari hospital.
Lord.
From there, in the night itself, he was brought to
Lord,
the
that-
international hospital. The PM was done in the medical college at Guwahati.
no, Lordship, page number, Lordship 51, Lord.
Yes.
Page number 51,
Hmm.
last paragraph, Lord.
51. Yes, please.
Taking him home, when we asked him about the incident, he replied, feeble voice, that after bringing him from Guwahati, the accused person had assaulted him in the house of Pandarpo first, and thereafter taking him to the veranda of Sangha, they again assaulted him and poured some obnoxious substance on his eyes and mouth. We tendered Pankaj by providing massage, etc., and sent him to Nalbari in an ambassador car that very night. First, he was sent to Nalbari Lordship that very night.
Hmm.
Then it was around 12:30 midnight.
Yes.
The following morning, Lord.
Yes.
The following morning,
Morning.
the doctor referred.
Yes.
First, on that day night itself, he was sent to Nalbari Lordship.
Right.
The following morning, the doctor referred Pankaj to international nursing.
Yes.
Next day, he was brought to international
Yes.
nursing. And accordingly, we have taken there and lost the apparent. So I wrote,
See,
And-
you kindly come to page 1, the format of the FIR. Kindly see 2 dates and the timings at page 1. Date and hour of occurrence 9/3/2002 at about 11 PM.
Lord,
Have you got, madam?
Lordship,
Then you come to the date and hour when reported. 10/3/2002 at 2:30 PM.
Lordship,
And where is this report? Report is at Gograpal.
Nalbari.
So after the incident at night on 9th, he was initially taken to
To Nalbari.
Nalbari, then he was
Next
referred to
day.
the international hospital.
Next day. Lordship, PW7, Lordship. Deep Chandra Das,
Page
page number 58,
58.
Lord.
Yes, please.
second paragraph, Lord. I found Pankaj in seriously injured condition in the veranda of Sangha, and Pankaj told me that Manoj and others assaulted him. Thereafter, the villagers went there, and we took Pankaj his house. We took Pankaj to Nalbari, Borua Hospital. From Nalbari, he was referred to nursing home. On the way, Pankaj died. Lordship, Pankaj told to this PW7 also, Lord, and there was the villagers, sir, along with him, Lord. Specifically, he have mentioned, Lordship, told that Manoj and others has assaulted him. PW7 and Lordship.
But why weren't there any mark of injuries on the body?
That is the thing, Lordship. That is only the thing, that how he died without anything, Lordship. A person cannot die, Lord. That also,
What is the opinion of the doctor?
a natural death, Lordship. How can
Natural-
it be natural death, Lordship?
No,
It
it
was
is- it is
referred-
for- It is for you to establish if it's not a natural death.
That
Just
is the,
raising the question will not do.
Lord,
Show
Lord,
us from the materials on record. It is the report of the doctor.
Lord.
He is one of the prosecution witnesses. And in fact, the doctor has been very fair in his report, saying that I cannot give the cause because without the chemical analysis, it
Lord.
was sent for chemical analysis.
Lordship, regarding this, Lordship, I am.
Yes, what is the citation?
Lordship, 2022 8 SC is 668
2022?
8 SC.
Six six eight.
Lord.
Paragraph?
Paragraph, Lordship, 31 is there, but in this, Lordship, paragraph is something different.
What purpose you were referring to this?
For doctor's opinion cannot be the last decision.
Page?
Lordship,
30.
paragraph 30, 31, 32. But Lordship in there. Hmm.
Yes.
See, 31.
Where is the in case report in this case, madam?
Inquest report lordship page number 171 to 173.
See, the inquest was done in the international hospital. It
Lordship.
was done in the international hospital. But no injuries found on, no injuries found on the back too. Black and no given. Injury also does not support you. No injuries found,
There, Lord.
even in the inquest.
Thing is that lordship, the deceased lord, the last dying patient, he have shouted lordship. The villagers were there lordship, and he was alive. Lord. He was in a feeble voice, but he was in a talking condition, lordship, speaking condition that the accused has assaulted him. They have poured some liquid substance in his mouth and eyes, lordship, and lordship, he was immediately shifted to hospital, lordship. There, then lordship, without anything, how, why, for what reason he will be shifted to hospital, lordship. And he was immediately from Nalbari, he was referred to GMCH, Lord, International Hospital, Lord, as he was serious, lordship. But his, I don't know, lordship, why the doctors have not referred any injury, lordship, or anything, lordship, detected upon the deceased body,
It's not a
lordship,
question of not referring. They have examined and not found.
not found. But lordship,
If it was blank that we have not examined,
they
matter
have
would have been a
even,
question of.
they have not even, lordship, suggested that due to stroke or something disease, that is also clear from the postmortem, that the disease have no disease, no injury.
See, that is why, again, we are repeating, the postmortem report, last part, he has not given any opinion.
Opinion.
He said that it may be a case of poisoning.
Po-
Since it is not within my ambit, I send it
So
for
these are-
chemical analysis.
Lordship,
So we depend on the chemical analysis. Chemical report says that no case of common poisoning.
common point. But the
Now-
cause of death is still not detected, Lord.
No, cause of that,
Natural.
he, in his cross-examination, he has said something.
Lordship.
Because it is the
Doctor's
confession
opinion.
came much
Lordship.
later. He said it appears to be a natural death.
Lordship. Once dying declaration, Lordship, as my learned friend has submitted, Lordship, it cannot be denied, Lordship.
No,
Dying
dying
murder.
declaration is the
And
relevant
that is
evidence.
corroborated, Lordship.
That is under 32 because the person is not in the dock. Even thereafter, the statements, those are admissible in evidence. Why? Because of section 32.
Lord.
Section 32 says that in spite of the fact that he is not in the dock, till then his statement is a relevant piece if it relates to the cause of death. Now he said that this person assaulted me, this person has administered something, poured something, not administered, he said poured. But there is no evidence of poison, there is no evidence of any assault, there is no injuries.
The bottle is seized, Lordship, but they have
Bottle is
not,
not, the contents of the bottle not
not,
examined.
not examined, but it is seized. Handkerchief, Lordship, it was also seized.
You have to connect it. You have to say that the bottle was containing poison.
Yes, Lord.
Yes.
That is it.
Anything else, madam?
But
Your Mubarak.
Lot.
For,
For response number 2, 3 and 4 mile. 2, 3 and 4 mile.
2 to 4.
But in this case, nothing is defined by the
Hmm?
logic is already. Nothing is defined by the.
Nothing is,
Remain my lord. Here plot already got my lord.
nothing is
Uh,
remain.
Lord.
That means
Uh,
your case of conviction is made out.
No, well,
Then what?
the conviction
remains
is not
in
made
law.
out by that. Your lord will see the FIR mark. Just 5 mile. Just 4 mile. After filing. With due respect, I beg to submit that I am the permanent resident of the Karamtola, Komortola, Suburi of Varkala Gaon under the Poop Bonbak Mode. My father's name is late Harisarandar. In the evening on 8/3/2022 Sunday, while I was not present at home on 8/3, Sri Kandarpa Das and his 2 sons, namely Sri Manoj Das and Sri Urup Das of the aforementioned village, forcibly took my youngest brother, Sri Pankaj Das, away from the house through some young youth, and thereafter they threatened him inside Smriti Sangha at Varkala. Because of the aforesaid circumstances, I, as a guardian, took Sri Pankaj to the house of my elder brother of Nunpat. He is the Lavanya, the Pankaj took him his elder brothers situated at Guwahati and left him there the morning hours on 9/3/2020. But in this case, my lord, neither his sister-in-law nor his elder brother come to the light matter, and they have not come to the talk for witness. And neither they have filed any Ezahar against the accused person. But the boys mentioned in the Ezahar again brought Sri Pankaj Das from Guwahati, and after committing assault on him at 11 p.m., they made him consume Dimecron, a kind of liquid poison, and left him at the veranda of Smriti Sangha in the moribund state. Thereafter, hearing the scream of Sri Pankaj, the neighboring people, not the informant male, the neighboring people wake up, and coming there with lights, they found Sri Pankaj lying in moribund state. Whereupon the boys entered the house of Sri Kandarpa Das at a return. Meaning thereby, my lord, the Lavanya Das was not present at the place of occurrence, as per FIR. Then, seeing the condition of Sri Pankaj to the critical, the villager rushed to him to nearby Borua Nursing Home, Nalbari, and got him admitted there. But finding this condition to the critical, the doctor of the nursing home has referred him to the neurological nursing home, Guwahati. This is the FIR, my lord. In this FIR, he clearly stated that he was not present at the place of occurrence, my lord. But in the PWS, my lord, PW1, he stated that he was the present and one handkerchief and one the bottle, my lord. He has picked up from there, and the state has been give to the police, my lord. Lord, to kindly see. Page 19,
19.
Lord. Cross-examination. It is not a fact that I did not state before the IO that my mother and sister told me that accused person, namely Kandarpa Das, Manoj Das, Urup Das, Kailash Das, Gautam Das, Khagen Das, Jogen Sharma, Babul Das, Dipen Das, Ratul Sharma, and Amresh Lakar took away Pankaj Das. It is not a fact that I did not state before the IO that my mother and sister were threatened. I filed the Ezahar before Pankaj died. In the Ezahar, I filed the Ezahar before Pankaj died. And the Azhar has been lost against only 3%, my lord. The family member of the Kondor Kotak, my
You are reading at 19.
lordship. 18, my lord, 8,
Cross-examination.
lordship, of cross-examination. In the Azhar, the names of accused persons who were later included were not given. On 8/3/2022, when I rushed to the Sohit Smriti Sangha, but in the FIR minus, he was not present in the place of occurrence. Kindly see. When I rushed to the Sohit Smriti Sangha, none accompanied me. None accompanied him, my lord. I found that the doors and windows of the Sohit Sangha were closed. I heard the Pankaj was being threatened inside the house when the door was open. I entered into the room and found the accused person left the room. After my entering into the room, the accused person did not do anything to Pankaj, meaning thereby they have not assaulted Pankaj. I took Pankaj to home and
This is the earlier evening. This is not
8/3 by
8/3.
8/3.
This is not the date when the assault
Lord.
and the pouring of this
Lord,
liquid was
on
done.
9/3, it is the 9/3 on in the morning 9/3, my lord. They took Pankaj to his elder brother's house at
Correct. Yes.
Kindly see page 19, paragraph number 2, my lord.
Hmm.
On 9/3/2022, in the morning at about 6 a.m., I took Pankaj to Nunmati, Guwahati, and kept him there in the house of my elder brother, Honindra Mohandas. On that day, my elder brother was at Jagi Road, but my sister-in-law, Kobita Das, was present in the house. I returned back in the evening.
Hmm.
He was present in till evening, my lord, in the Guwahati, my lord. And I did not, next para, I did not see any injury on the body of the Pankaj on 8/3/2022 and 9/3/2020. No injury mark. My elder brother or sister-in-law did not lodge any case on 9/3/2022 and also did not inform me anything about Pankaj. If one person has been taken from the Guwahati to his village, they should be informed, my lord, and they never come to the dock, my lord, for evidence, my lord. And lordship kindly see the last 3 line, my lord. Page 19, my lord. I personally did not see pouring of poisonous article. I found one bottle lying nearby and the cork of the bottle was open. A handkerchief was lying near Pankaj. I took the bottle and the handkerchief on that night to my home. In the FIR, my lord, he is not present at the place of occurrence. But in the evidence, my lord, he stated that I was brought to the scene from the place of occurrence and handed over the police. I was not seen the bottle and the handkerchief today in the court. I found smell on the face of Pankaj, but I could not recognize the smell. In the night of 9/3/2022, I took Pankaj to Borua Nursing Home, Nalbari, but he stated that the neighboring people took him to the Borua Nursing Home. But doctor of Borua Nursing Home referred Pankaj to International Hospital, Guwahati. Pankaj was in a position to speak quickly when Pankaj was at Borua Nursing Home. But in the Borua Nursing Home, there is no any dying declaration, my lord. As per my learned friend's statement, there is dying declaration, but doctor is present and he was speaking condition, my lord. But there is no any dying declaration. But I did not know if the medical officer of Borua Nursing Home recorded any statement of Pankaj. Now, your lordship, kindly come to the page 21, my lord. From the bottom, 5th line. Police came in the evening on 10/3/2022. Police seized the bottle and handkerchief from my phone.
Page?
Page 21, my lord. The handkerchief and bottle has been seized by the police from the house of the informant. Now come to the PW2, my lord. Nirupama Das. Except I were medical officer, my lord. All are the interesting witnesses. What should kindly from page 25, my lord. Kindly see page 26, my lord. Last 3 line, my lord. He also said
Page 20
26, my lord.
to 6.
26.
Yes.
He also said that after beating him up in the house of Kondorpa, they had brought him to the veranda of Sangha. When I shouted an alarm, a lot of people from there. The people took Pankaj to Nalbari for treatment. I did not go to Nalbari. Later, I came to know that he had been referred to Guwahati from Nalbari and that he had breathed his last on the way. In the 27th last paragraph, my lord, the bottle and the handkerchief were lying near Pankaj. A VDP member took the bottle and handkerchief away. But the PW1 stated that he took the bottle and handkerchief from the place of occurrence. But in the FR, he is not stated, my lord. He was the present of in the place of occurrence. I did not notice whether the cap of the bottle was open or fixed to it. Also, kindly see page 28, my lord. Paragraph 3rd, my lord. My husband does not stay at home. Pramod Das is my son. At the time of incident, he was pursuing his higher secondary course. He did not go there along with me. I found Pankaj lying on the veranda of the Sangha. When Pankaj asked to wash his face, other persons, namely Gauri, Pramod, and Rajiv, were present there. A lot of villagers also present there. Some vomit was there. I noticed injury on the person of Pankaj. I also saw blood oozing out from his person. That's the statement of the PW2, my lord. Kindly see, my lord, this statement, page 29, man. The second paragraph, Lord Supreme. Kondorpa's wife had lodged a case against my husband and son, alleging that they had burned their house. That is why he come to the dock, my lord, to give witness, my lord. And on 9th March, just after going to the Sangha, I did not meet Lavanya. There, police did not seize the bottle and handkerchief in my presence. In the last paragraph, my lord, kindly see. On 9th March, the people carried Pankaj to the house of Lavanya from Sangha. It is not a fact that my husband and son had set fire to the house, and since a case has been lost over that matter. And now PW3, my lord. Gaurisaran Das. Here's also interesting witness, my lord. And Lordship Palace page 32, my lord.
33. Gaurishwaran starts at 33.
Lordship Palace page 34, my lord. That he examined. Thirty-fourth page from 4th line, 4th paragraph. Accused person letter submitted.
Yes.
Accused person letter submitted on Azahar in the police station against us, alleging that we set fire on the house. In the first case, I was also made accused. I stated before the IR. Here's also the interesting witness point. And the last paragraph, my lord, I do not know as to the Pankaj was vomiting. I do not know who took bottle and handkerchief. I have not seen the bottle and handkerchief today in the court. Next paragraph. I heard that there was a love affair of Pankaj with Monica. I do not know. I don't remember if I stated to the IO that handkerchief and the bottle were kept in the house of Ramesh Sharma. And kindly see third paragraph, my lord. The house of Kandharba is about 250 feet away from from my house. I did not see fire on the house of Kandharba and Kailash. I am also one of the accused in the case lost by Monica. Moina. I did not see any substance on the face of Pankaj. I also not see any injury on the body of Pankaj. No injury mark is there, man. And Lordship, kindly see page 36, my lord, in the second paragraph. We took Pankaj from the Sangha to his home. We found Lavanya in the house of Pankaj, meaning thereby Lavanya is not present and the PW is not present, or Imhanba is not present, my lord. Or the place of
Where, page?
page 36, my lord. Second paragraph, my lord. We took Pankaj from the Sangha to his home. We found Lavanya in the house of Pankaj. Lavanya is brother of Pankaj. In the FIR, he stated that he is not present, and the PW3 also stated that Lavanya, PW1 is not present on the place of occurrence. Now will come to PW4, my lord. Page 41. Last paragraph, my lord.
40.
40, my lord. Later, around 10:30 to 11 p.m. that day itself, I heard a strike coming from the veranda of the Sangha. Then I was at home. I got to hear that sound, and as I returned home a bit later after attending a marriage ceremony. On hearing the sound, I went out to the road and heard a shriek of a person again. Then I assumed that the said sound had come from the field of the Sangha. Then I proceeded towards that direction. Then I saw the accused person present there. They prevented me from going ahead. As they prevented me, I raised an alarm. Hearing my alarm, the neighboring people arrived there, and all the witnesses stated that they had come from to the place of occurrence. Whereupon the accused person fled the scene. Some 6 to 7 people of the locality arrived there. Neighboring people, namely Deep, Kumud, Gauri, Nirupama, Harmohan, and other arrived there. Later, a lot of other people gathered there. After making an inquiry as to what happened, we found Pankaj lying there. He was lying there in an injury state. We noticed a layer of some with white substance on his eyes and face. Some white substance was found sticking on his face. Then we took Pankaj Das home. His condition was very critical. We took him to the nursing home owned by Nripen Malla Bujar Barua at very night and got him admitted there around 1 a.m. Since he did not recover at all, he was referred to International Hospital Guwahati, and accordingly, we took him to Guwahati at 10 a.m. on 10th March. While we were taking Pankaj to Guwahati, his condition deteriorated more. We reached International Hospital there. After examining Pankaj, the doctor declared him dead. Later, the police of Dispur PS were informed. Going there, the police examined the dead body and took it to Bhangagar to postmortem examination. Police prepared paper and held inquest. Police obtained my signature, exhibit 7 and crossed my letter, cross part. It was a dark night at the time of incident. I was at home when I heard the scream. I was on the road when I heard the sound scream. The second scream. I raised an alarm from the field, not from the road. At that time, nobody was there with me. Just alone, man. And Lordship, kindly see page 43, man. Paragraph 2, man. I am also addressed as Baputi. Accused Kandarpa's wife, Mainawala Das, lodged a case against me alleging that he used also the interesting witness. Mainawala Das lodged a case against me alleging that I had burned their house, properties, vehicle, and shop. The number of the said case is 144/04. 10 other persons and we were named as accused in the case, and Honorable Assistant District Judge convicted my 4 accused persons in that case and sentenced them to undergo imprisonment. Pankaj was breathing when we found Pankaj at the veranda. I did not touch the layers of white substances present in the of the face of Pankaj. Taking him to his house, we washed those out with water. The house of Pankaj is 8 to 10 hours apart from the
Houses, not ours.
houses. Apart from the place of occurrence, on 8 and 9 March, I did not notice any external injury on the person of the Pankaj. No injury.
No, 8 and 9, this 9th and 8th, eighth of the incident, earlier incident started on 8th.
Lordship,
9th morning, he was brought to Guwahati.
Lord,
And 9th evening,
Lordship,
he has been kidnapped or whatever,
Lord.
abducted back to
Lord.
this place.
Lordship.
So this injury is not after the incident of 9th evening. This is of 8th and 9th intervening.
In the in the in the 9th means 11. As per the statement and the FIR, my lord, the incident took place at 11 p.m.
Or 9th.
9.
Now, there are materials that even though they have said that injuries were there, but this injury is noticing is on the intervening 8th and 9th. 9th evening, the incident is a different incident. But one incident also occurred on the earlier evening. 8th.
My lord. Sir, 8 incidents, my lord, this person, they have not made the, they have made the decision after, only after the 9th night. So they are talking of the, my lord, after the.
After 9.
And
The 8th also they did not notice.
8 he is saying he has not, but 8
Then-
morning, my lord, he did know where it said it was the proper. His
No,
brother
the
has
question
taken
is,
him to
but see,
Guwahati.
this is a cross-examination.
Lord.
Did you notice any incident, injuries on 8th and 9th? He has to say no because he has not met the person at all.
It's not with the, on it, just not with the person.
9th also, before the incident, he has not met.
Yes, sir. After the incident,
After the incident.
Last paragraph, my lord. Accused Amaras Lakar's house is 4 kilometers away from our house in the east. Amongst the accused persons, 7 accused hail from our village. I came from Nalbari along with Pankaj on an ambassador car. I do not know to whom the ambassador belonged. When Pankaj was taken to nursing home, he was not capable of speaking. And the earlier, the PW stated that he was capable of speaking, man. But the PW4 stated that when Pankaj was, and he was along with the victim, my lord. And he stated that when Pankaj was taken to nursing home, he was not capable of speaking. And last line, my lord. It is not a fact that since Kandarpa's wife lodged a case against me, I have adduced false evidence against the accused person's truth. Now, your lordship, kindly come to the page 49. From 49, I'm starting from 51. my. Just 51 lot. PW5. Last paragraph. Who tended Pankaj to providing message, massage, etc., and sent him to Nalbari in the ambassador car. that very night. Then I was around 12:30 midnight. Then it was around 12:30 midnight. The following morning, the doctor referred Pankaj to International Nursing Home, and accordingly, he was taken there. Thereafter, we went to Ghagrapar police station and lodged the Ezahar. Lavanya Das lodged the said Ezahar. I wrote the Ezahar as per the version of Lavanya. Exhibit 1 is my Ezahar and Exhibit 2 is my signature therein and its type. Pankaj breathed his last on the way to Guwahati. Police took my statement. I have been working as a teacher for 27 years. And close part, my lord. I have mentioned in the Ezahar the names of only 3 accused persons. I have not mentioned the names of other accused persons. Mrs. Pankaj was the son of my father's elder brother. The interesting. And last,
No, Mr. Mubarak,
Sir.
related witness not
Okay, Lord,
necessarily becomes an interested witness.
no, my lord, no,
Then
not
in
related,
that
my
case-
lord.
In that case, there is
One
no
case has
witness.
been, another case against their my lord. That is why, my. Another one case has been filed against the accused. This
So they will not be competent witness.
lord may be blood.
They can be competent only because of cases, yes, such evidence we have to, while considering such evidence, we have to be very careful,
Sure.
cautious. But it's not that it can be discarded straight away. In that case, if something happens
Sure.
within the family, all will be interested witness, all
Sure,
our
sure.
family members. That cannot be a ground to discard as a whole.
And page 52, Lord, kindly see. Second, third paragraph.
Hmm.
Pankaj was at his house on 8th March. Lavanya to reside in that house. In the early morning on 9th March, Lavanya left for Guwahati, taking Pankaj alone. One Horendas also accompanied him. I heard that Lavanya and Horen had taken Pankaj along with the house of his elder brother. Along to the house of his elder brother, Phanindra Das, and left him there. I went to school on 9th March. I did not see who came in the vehicle that entered the house of Ekes Chandorpa in the evening. I did not see, it is true, how Pankaj had come to Barkhala village that day. I did not also see it as to how Pankaj had come to the veranda of Sangha. On 8th and 9th day of month, I did not see any injury on the body of Pankaj. And Lordship kindly say, I do not know what was rubbed on the eyes of Pankaj, but I noticed a drastic change on his face. He was lying prostrate on the veranda of Sangha. Metal exhibit 2, that is, the bottle was lying there. I don't know what the bottle contained. The handkerchief was lying near Pankaj. Vomit was also there. I do not know who took the bottle and metal exhibit 1, the handkerchief, away from the place. I don't know who handed over the state metal exhibit 1 and metal exhibit 2 to police at the time of seizure of those articles. But someone among us handed over those articles to the police. And kindly, Lord, to kindly come to the page 54, my fourth paragraph, or fifth paragraph. I was convicted in the case lodged by Chandorpa's wife, Maina, on the allegation of setting their house, vehicle shop, etc. on fire, and I was awarded punishment in connection with that case. Assistant District Judge disposed the case, said case by passing and judgment. When Pankaj uttered the name of accused person in feeble voice, other people, including Baputi and Deep, were also there along with me. It was not the fact that I did not state that fact to police. I informed nothing to police regarding the incident and happened on 8th March. Earlier, I adduced evidence in this court once in 2004. Pankaj's elder brother, Phanindra, did not lose any case with Nunmati police station. The important, my lord, I have adduced false evidence today out of that I have harbored because of the case lost by.
This is the wrong solution.
Wrongly recorded.
In the LCR also that is there, my lord.
It is not a fact. really.
In the LCR also there, my lord.
Understood, it's wrongly
Yeah.
recorded.
And PW5, another PW5, my lord, is the scientific officer, my lord. The earlier was PW5 and PW6 is not there, my lord. The PW5. And the last paragraph, my lord, result of examination, exhibit number TF 134A to TF 134F gave negative test for common poison. Exhibit 3 is my report, exhibit 3(1) is my sick. Exhibit 4 is the forwarding report of my examination report, that is exhibit 3, which was sent by the director FSL on to CGM Kamrup Guwahati. Exhibit 4(1) is the signature of the director Robin Datta FSL. Now come to the page, witness number 7, my lord, Deep from the dark. PW7 lordship, kindly see the first part, my lord. The villagers, last paragraph. The villagers cremated the dead body of Pankaj in the courtyard of Kondor Pradas. I was not present at this cremation. The villagers burned the house of Kondorpo and I was accused in the case laws for burning the house of Kondorpo. My statement was recorded by police. It was not a fact I did not state before the IO. I stated today in the court. It is not a fact that I did not state before. I owe the names of Kailash, Monos, and others. The villagers found a bottle of poison at the place of occurrence. When I went to the place of occurrence. There was no other person except accused person. When I raised Allah, villagers came. Hearing my noise, villagers went to the place of occurrence. And PW8, my lord, lordship, medical page 61, my lord. The postmortem symptom found in the dead body usually occurred in the case of natural. Opinion. So, opinion, lordship, jar number 1, 61 page, jar number 2, sample of preservation use, saturated solution of the sodium chloride. Opinion. Opinion regarding the cause of death was kept pending till the receipt of the report of chemical analysis of Hysteria. Exhibit 5 is the PM report. 5(1) is my signature. Congestion of brain, liver, kidney, pleuria, lung, and mucosa was due to natural physiological process due to death. And PW9, my lord, IO, my lord. Cross part I have written. Page 63, my lord. I received the Azahar at PS on 10/3/2000 at 2:30 p.m. It should be 2002, my lord. The seizure articles are not available before the court today. Inquest was not done by me. Dead body was not sent by me for the postmortem examination. I did not send the viscera of the dead body of FSL examination. PW1 Lavanya Das did not state it before the IO that Kailash Das, Gostam Das, Khagen Das, Jogesh Sharma, Babul Das, Dipen Das, Ratul Sharma, and the Amaresh Laukar took a Pankaj Das. PW1 Lavanya Das did not state before the IO that his mother and sister were threatened by the accused person. PW1 did not state before the IO that Pankaj told him that he would be killed if he, Pankaj, would not marry the daughter of Kandharpa. Monica is the daughter of Kandharpa and sister of the accused Manoj. The witness PW1 did not state before the IO that he had found I am dying. Date of seizure on 10/3/2022. Statement of witness Nirupoma Das was recorded by the IO on 10/3/2022. PW2 Nirupoma Das did not state before the IO to have seen accused person assaulting the accused Pankaj Das. PW4 Gaurisaran Das did not mention before the IO the name of the accused Kailash Gautam Jogesh and Amaresh Lakar, but he stated before the IO the name of the Manoj Das, Purup Das, and Kandarpa Das and others. PW3 did not state before the IO that Pankaj told him that the accused person took him from Guwahati and assaulted him in the house of the Kandarpa. It is not a fact that I did not investigate the case properly. And a PW same with the IO matter, one ASI. It is not for UC, not necessary. And the as per the inquest report, FSL from PM report, my lord. Last report, inquest report, my lord, test 1771.
That was done that was done in the international hospital.
Lord.
No injuries is seen.
No, in the FSL report, one is stated by that negative test, right? PM report also,
Inquest was page.
test 171. One relevant 172, my lord. And the FSL report was 174 much.
— 174. Exhibit
Result of
what?
examination.
Exhibit?
Result of examination, my lord.
Now, what is this exhibit as well?
The exhibit number of 134 A to
No, no,
1.
no. In the proceedings, exhibit what? Proved as exhibit 3 or what? Then what is the inquest report? Inquest is also exhibit 3.
Also exhibit 3. In page 75, it is exhibit 4 stated, my lord.
Hmm?
Page 175. Exhibit 4.
That is not the report. That
Not-
is the letter.
not-
The report is at 174. Kindly come to the stamp, the portion which has been
Not
stamped,
me.
exhibit
Three.
3.
Yes.
And kindly come to 2 pages.
Exhibit 3 1.
2 pages.
Not-
That is also exhibit 3. Why?
This one.
Okay, doesn't matter.
And in this figurement, I am relying on Brazilian method of our High Court method. 2001 4 DLP 06.
2001,
2004 1 DLP. Best previous experience.
1 GLT.
Yes.
3,
06.
name,
Sitaram Das versus State of Birth. Small subject. This and then the death of 7-month pregnant housewife, appreciation of evidence, perversity, autopsy over the dead body not showing any injury. Viscera of the deceased sent to the forensic science laboratory and the report not made part of the record. As per the finding of the scientific officer of the FSL, the sample of viscera gave negative test for poisoning. Case held to be there, no evidence, conviction under seriously expert. This point out, I conclude my argument matter. I pray your lordship matter. The appeal may be dismissed after the judgment. Public.
yes.
I have my
Thank you. Anything?
I'm accepting his submissions, my lord, already, my lord. Furthermore, that is one thing I would like to put in the notice of the court, my is that, my lord, all the witnesses, those who have been present in the place of occurrence, according to them, they all have gone there first. Lavanya also said that he has reached the place of occurrence first. Then the PW2 also, he is also saying that, my lord, he has reached the place of occurrence first. PW3 is also saying the same thing. 4 is also saying the same thing. Well, all these witnesses, they are saying that they have reached the place. And even 4 has said that he has reached the place. He has raised Halla, south, and then people came. But the veracity of their statements, there is not, it's a question, my lord. No one is saying that I have reached after Lavanya PW1 or after PW2. They are saying that we have reached here first. Secondly, my lord, except these, my lord, these people, all these witnesses, my lord, official, and they all are, my lord, involved in that case which has been filed by the wife of Consul. This is another aspect. Police has not examined any other witness, my lord, or no one has come forward to give witness except these people. Father of the deceased was there, sister of the deceased was there. No one has come forward to give any evidence. Only the persons who are involved in the police case, they have come forward to give evidence. Well, Another, already there was a discussion, my lord, with the submitted, not very repeat.
Year for,
5 to 12, my lord. We have been brought later on, my lord. We are not named in the FIR also. The statements, my lord, it seems that from the statements of the evidences on the cases, the witnesses are trying to develop the case also,
you are not initially charged also.
not charged also.
Yes.
But-
Anything, any further,
So far, my lord, prosecution side, my lord, the government side is concerned, my lord. They have not come up for any appeal, my lord, against this acquittal, my lord. Now they are submitting in favor of the, my lord. This, my lord, appellants, my lord. With me, my lord.
yeah, they can do so. They
They
can,
could have come for appeal, my lord.
that is okay, but they can still take a stand. Anything more, madam? You have already argued.
One thing only I would like to point out, Lordship, that about the pouring of something that is not detected, there may be lot because, Lordship.
Look, Sitaram, who had cited? Sitaram?
Lord,
Mubarak has cited.
two witnesses, Lordship, PW 2 and PW 2 and Lordship, who have said they have watched the face of the deceased Lord. When he has out, he have taken, they have taken him to the home and in page number 26, Lordship. In page number 26, third paragraph, Lordship, PW 2. See, then I heard someone uttering Morilu, Morilu, I am dying. We came out and casting the torch, I saw the accused person and Manoj Das there. They were assaulting Pankaj Das. Pankaj asked us to wash his face. He also said, something has been poured in my eyes. I saw a bottle, so and so, Lord. There and Lordship in page number 43 also, Lordship.
Yes.
In the cross part, Lordship.
Hmm.
Third paragraph, Lordship. Pankaj was breathing when we found Pankaj at the veranda. I did not touch the layer of white substance. There is something white substance. Presence of the face of Pankaj, taking him to his house. We washed those out with water, Lord. They've washed it, Lordship. And the thing that in PM also, Lordship, we have the deceased have said that something is poured in my eyes and mouth is rubbed with a handkerchief.
PM.
In PM report, Lordship, eyes are not examined, Lord, because deceased have complained about something is poured in his eyes. That is not examined, Lord. In PM report also about eyes, nothing is there, Lord. And the deceased was shouting that something is poured in my eyes, I could not see.
Eyes closed.
Eyes closed.
That is what is written in a PM report.
The eyes closed, this is that because the deceased have complained about the eyes only, Lord. If something is for which he was unable to visualize the thing, Lord, could see. Because there is no such reason given natural death, Lordship. But everyone is saying that he was serious when he was taken to the hospital, Lord. So he was referred, Lord. Yes, Lordship, I'll leave up to you, Lordship, because there is some.
So I have concluded that I want that one thing. My learned friend, my lord, preparing for a restaurant number 5 to 11 state, my lord. Everybody is coming fast because of this night, my lord. It is 11:30. So possibly nobody has seen, everybody has come. Yes, my lord, everybody has come, I have come first, I have come first. Later on,
No, there is a question. There was none when I had come. He has qualified.
But-
You may be correct. At
My
the
lord.
time of night, in
My-
the hustle and bustle, who came first may be a question, but there was a qualification that when I had reached there were none.
so was present, I've seen that, but even then, my lord, maybe because of that night, my lord, they have not noticed other that time find it. And my lord, secondly, my lord, at least my lord, here is a my lord, he has been Guwahati from to Nolbari, at least he has been kidnapped, my lord. That part is my lord proof, my lord. Though there is a no section has been my lord.
There was no charge of kidnapping
My
or
lord,
abduction.
It can be altered also, my lord, before passing the judgment.
How?
also. And court also can refer to the my lord
No,
trial court.
how can it be altered? These are not the
No.
connected offense.
My lord,
Had it been a connected offense, these are
My lord.
separate offenses.
though my lord, in the FIR, the kidnap part, my lord, they have not specifically stated, my lord. That, but they have brought them. Even the two person also said that while taking to Guwahati, my lord, they have seen him in the morning, my lord. And only my lord, left on my part, my lord, is that we could have filed an FIR in the Nunmati, my lord. Or would have been a witness, the sister-in-law of the my lord, deceased, my lord. Because brother was away that day when he was dropped in Nunmati. Brother was in Jagirot, as per statement of the PWD.
So if you come to the only provision in the CRPC is 222.
Sorry, my lord, I left in.
Please read.
My lord. When offense proof including in offences, when a person.
Included, not including,
My lord.
included.
My lord,
Included in offense charge.
yes, my lord,
When
when
a
offense proof included in offences. When a person is charged with an offense consisting of several particulars, a combination of some only of which constitute a complete
Minor
offense.
offense.
and such combination is proved, but the remaining particulars are not proved. He may be convicted of the minor offense, though he was not charged with it, my lord.
This is a completely different offense. Kidnapping, abduction is a completely different offense.
Here is a my lord left on the investigation part, my lord. So to say, otherwise the person died due to because of this, my lord, assault and on, but
And
due to-
yesterday, Mr. Sarania, we had asked you about this substance. This
My lord,
substance. Did you
like-
make any research?
my lord,
Did you make any research?
my lord, I think my lord,
You forgot after going from the court.
my lord, I didn't find my lord,
You did not find, did not search.
Right.
We searched for you.
my junior,
No, you should take the responsibility. There is a wrong description in given.
Right.
There is a substance
my,
which is used as a pesticide. It's a toxic substance.
my lord.
What you are reading is a medicine for diabetes.
My lord, I did two, my lord. The
No,
first part was,
You read medicine, diabetes for medicine cause which has metformin. That is not the
my lord,
substance. There is a mistake in the spelling. This is a pesticide. It's a poisonous substance.
Right.
But unfortunately, it was neither seized properly nor it was verified
There is-
or examined.
there is no proof at all that whether it is
The
that
spelling
kind
is
of-
slightly different.
my lord.
You see what was the spelling here?
My lord, yesterday I check up, my lord.
No, that is not the thing.
He has a two spelling, my lord, sometimes. Calculate, yes, my lord.
Not Damcron, DAIM.
DAIMCRON.
This is a medicine for diabetes.
My lord, Yesterday I searched my dichromat, my lord.
No, not dichromat, that is another thing which.
That is a toxic, my lord. Acute dichromat toxicity is a rare and usually fatal event, my lord.
No, no, what is the name of the substance? It's an insecticide. It starts, the phonetic is almost like diamcron. It's different. There was definitely something, but it's a very faulty kind of a prosecution, investigation,
My lord.
very faulty.
My lord.
Because the smell, about the smell is there in the PM report, but it's not clearly proved.
No, smell will not take us neither here nor there. It has to be proved in accordance with law.
Right.
Seize the substance, get it verified by the official
lord.
report.
That because white substance was there in his mouth. And
Now,
they was-
how they could write this particular term in the FIR? That means they were aware
that
that there was a poisonous substance used.
Right.
The term which they have used and term which were yesterday verified, these are not matching. There is a medicine called Diamcron. It is used for
diabetes
sugar.
and sugar.
It,
blood
it causes it has metformin.
pressure. He was also immediately
The
taken. blood
secretion of the insulin is done. Not this. There is another term.
hospital.
And the police did not even go to the place of occurrence.
And he was treated for
Was the sketch map prepared?
My lord. Last,
there.
Page,
Page number 191, Lord.
where is the place of occurrence?
He is
Age-
the house of complainant.
age the, my lord, the
So
place of
it's-
occurrence.
So
A.
it's the place of occurrence.
E the LP school.
He is the house of.
House of complainant C.
Well, let us read the IO again. IO.
W9.
62. Sixty-two.
In here it is written, Lordship, dimochrome. Spelling, Lord. Spelling is not that one. It is dimochrome. Poison dimochrome produced before SI. That is,
Where are you getting?
Lordship,
Last
page
line.
number 62,
Last line.
down last paragraph, third line, Lord. Suspected to contain. That spelling, Lordship.
What is the meaning of this?
Lordship, and
If you are already suspected to be a poison, why didn't you do an FSL? Chemical analysis.
It is telling to no.
What the SI, the SK Talukdar had done after going to the place of occurrence, nothing has been stated. He very boldly, proudly says that I entrusted SI Sushil Kumar Talukdar to investigate the case. Subsequently, for better investigation, I asked SK Talukdar to hand over this case diary to me, and accordingly, he handed over case diary. And he has done a better investigation. He has not even said what he has done after going to the place of occurrence. Did he collect anything? There was vomiting.
No.
There was this bottle. Very perfunctory kind of investigation,
Investigation is
just for the sake of it. Nirupama did not state before him that he has seen the accused assaulting. Okay. In continuation. No, hard for you, huh? Hard sentences. In continuation of the arguments, comma. And in continuation of yesterday's proceeding, comma, Miss E. Begum for the state respondent, comma, Sri Mubarak, Learned Counsel for the Sono 2 and 2, and Sri Yudhe Sekya, Learned Counsel for the respondent number 5 to 12 have completed their arguments. Hearing is concluded. Judgment is reserved. Okay, well considered.
Hello.
But have come up for the first time since 2021 lordship. We are unable to contact our client lordship. Lordship will grant us 2 weeks time lordship to seek instruction lordship. What is the present status lordship? Yes, ma'am.
And what is very old matter, 18 matter.
But-
Other side, who's there?
Post this reflects the name of Mr. S. Nathan.
Yes, Rana.
That's the post it.
What is this appeal about?
Lordship, appeal under section 19, Lordship, against
No, no,
the,
against what?
passed by, order dated 27/10/2017, passed by the learned principal judge, family court number 2, Kamrup.
No, that we know. What is
Lord.
the appeal? You are the husband.
I'm the husband. Lord.
Your application for, your suit for divorce has been rejected.
Rejected, Lord.
There was a criminal case against you.
Lordship, I have to take instruction regarding that, Lord. It's the only-
No, there was. You
There
were
was,
con-
there was, Lord.
You were convicted. for-
Admittedly, it was.
What do you do?
Lordship, not on the Vakalatnama, Lordship.
That doesn't
Lordship,
answer.
understand,
If you should have the brief, you should
Lordship,
know.
Lord.
Don't say I don't have not signed Wakalatnama. We will have it, but we'll take this up.
Lordship.
Today we are granting you some time. Your A. Gautam
I'm N. Gautam.
and Gautam. Sri N. Gautam, learned counsel appearing for the appellant, has sought for some time as the client is not in touch for a long time. Full stop. None appears for the respondent on call para. In the interest of justice, matter is adjourned by 10 days.
Sure.
To enable the council to have instructions. Yes. Okay. After 10 days. Item. Item 8. None appears for the parties on call. Para. There has been continuous non-representation on behalf of the appellant, as would be reflected from the order sheets. Orders dated 11/3/2020, 13/12/2021, 14/12/2021, 21/3/2023. Full stop. In fact, this court in the order dated 14/12/2021 had indicated that if on subsequent call and that if there is no representation on subsequent call, adverse order would follow. Para. In view of the aforesaid facts and circumstances, we have no other option but to dismiss this appeal for want of prosecution. Appeal accordingly stands dismissed. Send back the LCR.
Herein, my lord, the conviction is under section 302, my lord. Arrive for life. Sentence part, your lordship will find at page 44. Page 44 of the paper book. The accused is sentenced to rigorous imprisonment for life and fine of Rs 1,000. Only in default, further rigorous imprisonment for 2 months for committing the offence under section 302. Lordship coming to FIR, my lord, lordship will find at page 4, my lord. FIR informant name,
Wait for a while, don't hurry up.
sentence part.
Just wait for a while, don't hurry
Yes,
up. Wait for a while. You appear as amicus.
Yes.
And Madam Jahan will be appearing. Informant is PW three.
Yeah.
Okay, please read the
Yes,
yeah.
my the
Date,
page, my lord, page 4.
date,
The accused happens to be the brother in
date,
page 4, my lord.
date. Date,
What date?
date of the FIR.
No date, my lord.
Tell us
It's undated, my lord. First, at page 4, lordship will find.
what date.
It,
Say it's not dated.
but that has been received, my lord, and registered as Tamulpur case number so and so.
There was no date given in the Azahar.
Yes, my.
Okay, what is it?
Regarding date, I am coming. There is major
FIR
contradiction.
by
I have the-
PW three.
Yes, my lord.
Okay, please read.
I have the honor to state that around 5:30 p.m. today. that is-
Today, that means 4/3, okay.
Yes. That is on 4/3/21, while my father Jogen Boro, aged 55 so and so, was sleeping inside the house, the above named accused person trespassed into our house and killed my father by repeatedly beating him on the left side of the head with a faluka bar, a kind of bamboo. Later, I came to know at about 6 p.m. Later I came home at about 6 p.m. and saw my father lying dead on the bed. I immediately informed the villagers about the incident, and thereafter, on being informed, the police came, apprehended the accused, and took him to the police station. But from the bare perusal of the affair, it appears that there is no eyewitness, as on the perusal of the affair, my lord, that, my lord, this accused happens to be the brother-in-law of the informant. My lord, regarding this, my lord, date part, my lord, kindly come to page 18, my lord. Just to show the contradiction in date, my lord. The I was evident.
We'll go serially, don't worry. We'll go serially.
Okay, okay, my
The allegation is that his father was sleeping inside the house
yes, ma'am.
at 5:30 p.m. on 4/3/2021.
Yes, sir.
And this appellant
Hmm.
had come inside the house and assaulted him on the left side with a bhuluka bar.
Yes.
And this informant had come home at 6 p.m.
Yes.
and saw the father dying.
So there is no eyewitness. Proceeding to county next page, my lord. The charge framed with two heads, my lord. Firstly, page 6, my lord, that you on 4/3/21 at village so and so at about 5:30 p.m. committed house trespass by entering into the dwelling house of the complainant so and so in order to commit murder of father so and so, and thereby you have committed an offense under section 450 for house trespass, my lord. That secondly, that you on the same date, time, place committed murder of Jogen Bora, father of the complainant, by intentionally causing death. Thereby you have committed an offense punishable under section 302. My lord, shall I go to the evidence of the
Yes.
complainant first, the informant?
No, first, go serially.
Okay, my lord. PW1 is the, my lord, doctor, my lord. Dr. Teron, my lord. Let us see, my lord.
There are two charges,
Yes, my lord. 448,
450.
450, my lord. For trespass, my lord. And 302.
Okay.
House trespass in order to commit offense punishable.
450. PW1 at page 8.
Yes. So, he has stated about the injuries, my lord, and lordship may come.
Who
to
is
the-
he? Doctor.
Dr. Teron,
Okay, please read.
my lord, the injuries he has mentioned, and lordship may kindly come to the second last line, second two last lines, my lord. In my opinion, that death was due to coma as a result of head injuries sustained over forehead and face. All injuries are antemortem caused by blunt weapon. No mention of any object, my lord, as such. Holukaba, something like that. Time since death, my lord, next page. Time since death 13 to 14 hours. All this, why I wonder, my lord, why he is not taken to hospital. Deputy, my lord. The cross-part lordship will come. Skull and scalp were found healthy at the time of PM examination. Such injuries may be possible by falling on a hard surface. Apart from the aforesaid injuries, I did not find any injuries. Prior to death, the accused was in coma. It cannot be ascertained by means the victim was in coma. If proper and adequate treatment is given instantly, immediately after injury, the victim may survive but not always. No, it can be other than injury caused by any plant treatment or any it can be fall due to heart surgery. It can come to my lord PW2, my lord. She happens to be the daughter-in-law of the deceased, my lord. I know the accused Ritu Ramcheri. He is my elder brother. The informant is my husband. This is Jogenbaro was my father-in-law. I have forgotten the actual date of incident, ma'am. He has not stated the actual date. So charge state the date has to be there, my lord. The incident took place at about 6 p.m. So from 5:30, she comes to 6. On day some 6 months back, my father-in-law was sleeping inside the house. The accused came and entered the house of my father-in-law and assaulted the latter with a bamboo stick. Bamboo stick, man, not a bhaluka bar. I witnessed the assault. Here she says this she has witnessed, my lord. Noticing the incident, I raised alarm. The villagers came. And after apprehending the accused, they handed him over to the police. My father-in-law sustained injury, so he died immediately. My lord, the police question about the incident. I informed my husband about the incident over phone. She informed the cross-part, the accused is my elder brother. My elder brother on that day used to scold my father-in-law harshly and also get enraged. My father-in-law said nothing. My lord, in criminal case, motive is very important. There has to be motive as to why he has done this offense. Without motive, any lunatic, he has to be insane, something like that. Now, all of a sudden, he being the brother in her brother, my lord, he will come to her place and she will hit her father-in-law. No such causes, reasonable cause arise, my lord. As to why? She should have given any motive there earlier there is a rivalry or something like that, heat of the moment. Nothing has been absent, my lord. Why outraged and assaulted, my lord? Not stupid. Motive is absent, my lord. So, my lord, next page 12, my lord, PW3. Now, in his evidence before the court, he has modified his version, my lord. What he said, the informant, my lord, I am the informant. Exhibit 2 is the Azhar lost by me. Exhibit 2(1) is my signature. Person of the police station wrote the exhibit 2. He has not written person of police station. The Azhar, as per my version, accused Ritu Ramcheri is my wife's elder brother. This is friends with my father. The incident took place. I was 6 months back. The incident took place in the evening on 4/3/21, my lord. Time not stated, my lord. I was not present at my house. I was present in Sadhu ceremony held in a family of our village. My lord, to whose family he went is silent. They actually assaulted my brother on the head and face with a bulukaba, a kind of while he was sleeping. My wife called me over phone. My lord, this part he has not stated in affair regarding calling of her by wife, my lord. And also informed me about the incident, man. I came home in a run. My father was lying dead on the bed and his head and face was smeared with blood. My lord, in the scissor list, nothing such blood, nothing was, no blood clothes, stained clothes was recovered, my lord. And evidences repeatedly saying smeared with blood, soaked with blood. I will come to the scissor list later on, my lord. The villagers apprehended the accused and brought him. The police came and arrested the accused. The police took the dead body of my father and the accused to Kamalpur PS. My wife witnessed the accused. Now he is repeatedly saying, here in this evidence before court, that my wife witnessed with test manner the accused beating my father to death. Police questioned me. I lost the Azhar so. Exhibit 3 is the inquest report. My signature. Police obtained my signature when they seized the village, when they seized the piece of bamboo. My lord, he is saying, but in seizure list, Lordship will not find his signature, my lord. Cross part, my lord. I did not witness the incident. It was not a fact that I have falsely stated that my wife had told me about the incident. It has not been mentioned in the Azhar that I heard about the incident from my wife. It has not been stated. He has admitted, my lord. I heard the incident from my, not to say, my lord, regarding eyewitnessing, my lord. So the evidence of the PWC is not at all, my lord, acceptable, my lord. Not trustworthy, I should say. The next page, my lord, PW4, my lord, page 14. He is Jogesh Borom, and interestingly, if your lordship goes to the seizure list, my lord, 3 seizure witnesses examined, and only one of them has been examined before court. See, there are signatures of 3 persons, only one has been examined. This is Jogen Boro, my lord, Jogeshwar Boro. I know accused Ritu Ramchari, he belongs to my village, neighbor, my lord. I know informant Goswami, I also know the victim. The occurrence took place on 4/3/2021 at about 5:30, about hearing hue and cry at the house of the deceased Jogen. I, along with my neighbors, we arrived in the house. So was running away with a lathi. I saw Jogen inside the house. We noticed injury of Jogen with the footage apprehended. Cross part, my lord. He has also stated lathi, my lord, lathi, not bamboo. And after hearing hue and cry, my lord, that means there are more than the hue and cry, my lord. There has to be more than a good number of person has to be there, my lord. So cross part, my lord. Jogen Boro was son and daughter-in-law. At the relevant point of occurrence, son of Jogen Boro was absent, but his daughter-in-law was present. I did not see accused. I did not see the accused assaulting Jogen Boro. The occurrence took place at about 5:30 p.m. and there was little darkness, my lord. So if there is darkness, how can I see a person, my lord, running away with a lathi, my lord? Cross part that has been demolished, and my house is at a distance of half kilometer. The half kilometer means 500 meters. How he can hear the hue and cry, my lord, from half kilometer? From the house of Jogen Boro. He said, so all these are demolished. There are houses of other people in between my house and houses of Jogen Boro, my lord. This is absolutely false, my lord. If your lordship goes to this, my lord, sketch map, only house of one person will be there, my lord, and all other bamboo, jungle, everything. I did not chase Rathi in order to apprehend. He did not chase, my lord. But the informant says that villagers have apprehended him. I saw Ritu Ramchari was running away from his house at that time of occurrence. No lathi mentioned, my lord. In cross, he said running lathi in chief, and cross says no lathi, no bamboo lathi or anything like that, my lord. It is not a fact that you see students fleeing from the house, not a fact people running away, not a fact total darkness. So the next, my lord, PW is important, my lord, because he is the seizure witness, my lord, and he has stated about the lathi, my lord. The next, my lord, PW5, Babul Storgeri, neighbor. My lord, interestingly, his evidence, the Karnataka court below did not discuss, my lord. Why did not discuss? I will come. Second paragraph, my lord. The occurrence took place on 4/3/21 at about 5:30. My house and house of Jogen Boro are intervened by one house of our neighbor. Hearing hue and cry raised by daughter-in-law, we immediately came to his house, and on the way, I saw so-and-so was fleeing away with lathi on his hand. After entering into the house of Jogen Bose, we saw his head and was smashed. He was lying dead on the bed and blood was coming out from his head. Thereafter, villagers apprehended Tuenso. We handed over. Tuenso police came to the place, my lord. He has stated about, my lord, about the blood, my lord. So, first part, when I arrived at a place of occurrence, I found daughter-in-law of Tuenso and other villagers. My lord, he has not stated about the dead body in cross, my lord. I did not see the actual occurrence of assault on Jogenboro. Hearing Halla, I went to the house of Jogenboro. Before the occurrence of Jogenboro, Jogenboro had his lunch at the house of my elder sister on the occasion of Shraddha ceremony. And like that being so, my lord, this particular lady, whose place she went to attend the Shraddha ceremony, he should have been examined, my lord, the important witness. We had good relation with Jogenboro. My elder sister's house is at a distance intervened by one house from the house of Jogenboro. But my own house is a distance of 20 meters from his house. All this will nullify for going to the sketch map, my lord. No house such as, my lord. I will come later on, my lord. I did not know if there was any personal animosity of Ritu and Jogen, my lord. No motive, my lord. Ritu is the brother of the daughter. It is not I went to a place at the time of occurrence. At the relevant of time, there are few people at the house. At the house of my sister, and they were busy.
Okay, we'll come back at
Yes, sir.
2 o'clock.
You think up to not also that also, but
No, no.
Sir.
No.
I was in page 17 of the paper.
Sixteen is who?
Page 17, Pabul Sargiari, PW5. His evidence has not been discussed by the court, PW.
Not discussed.
Not at all discussed.
Let us see. Page 16.
Page
Page 16 is PW5.
PW,
Babul.
Pabul Sargiari. The page 17, I was in page 17.
Just a minute. Just go slow. He is a inhabitant of the same village.
Yes, sir.
Co-villager.
Yes, COVID. He has stated that they are lying in a pool of
On the occurrence took place on 4/3. And they were intervened by one house. One house in between. One house in between. Then you're hearing here by my daughter and by daughter. We came in the house and saw clean away lathi in his hand.
page 17, my lord. I did not know. Second, I did not know if there was any personal animosity between Ritu and Jogen. Ritu answer is the brother of so and so. It is not a fact. I went to workplace at the time of occurrence. At the relevant point of occurrence, where there were few people at the house of my sister, and they were busy to arrange pandal matters as Shraddha was over. Well, that is so, my lord, not a single of them has been examined. Just one house, as they say in their evidence, just one house away from that of the house of the accused. It is not a fact. I did not see him fleeing away from the house of the Jogenboro with lathi in his hand. It is not a fact that I am deposing falsely as I have good relation with Jogenboro. These are all got up witnessed so far. My submission is concerned. Next, my lord,
Just a minute. Don't go so fast. Oh, going to have lunch. Okay. See, your submission that the other people were not examined. Who were the other people? Other people were there
My
at
lord,
the
this,
house of his elder sister.
that is neighboring, my lord, just one house.
You read 17 first line. Before the occurrence,
Occurrence,
Jogen
Jogen
Boro
Had his lunch
had his
at the
lunch
house.
at the house of my elder sister. Whose
Oh.
elder sister? Babul's elder sister.
Yes,
On
my
the
lord.
occasion of Sardha ceremony.
Yes, my
We had good relation with Jogen. Elder sister's house is at a distance intervened by one house from the house of Jogen Boro.
Yes,
From the house of Jogen Boro, it is it is one house.
yes,
But from my own house, it is at a distance of about 20 meters.
yes, my lord. He nearby, my lord.
Nearby, but
Yes,
it is
my
not
lord.
the place of occurrence.
Now, that is what I am saying. I am saying in the sense because had that been the case, my lord, that these people would have examined, my lord. There was a hue and cry, everyone came, and not all of them has been examined.
No, is examination of all the witnesses required?
Because there are major contradictions in the.
No, if you can find out or show us major contradiction, then
Yes, my lord.
the
Because
quantity.
this IOS evidence that will be declared. I have not come to the IOS evidence.
But the Sardha ceremony
And this
was not-
sketch map will also make your lordship clear, my lord. Because there is only one house as per the sketch map. No house nearby, my sketch map. So, lordship was the sketch map.
How does it help you?
My lord, because these are all, my lord, these witnesses are not at all credential, my lord. Are more so, my lord, all the witnesses saying blood is there and scissor list, lordship will find 3 scissor witnesses were there and only one of them has been examined, my lord. And my lord, it says that only a 3-meter stick, my lord, recovered, and that too, no blood, my lord. How can that be, my lord? There were, this wearing aprons might have been there, my lord, full with blood, bed sheets and everything. That nothing has been seized, my lord. And they say, witnesses say that he ran away with the lathi. And IO says that I recovered it from the place, full with blood, my lord. There is no blood in the scissor list, my lord. My lord,
No,
PW6, my lord.
no, no.
IO.
Kindly come to the scissor list. Don't make a submission like this. Page 57.
My lord, I was about to, my lord.
57.
One
50,
by
you
one.
said that it was
IO,
taken away from him, then somebody IOC from the place. of
IO's
occurrence.
evidence, let us come to
No,
IO's
no,
evidence.
come to page 57.
Yes, ma'am.
I, Vijay Kumar Das, do hereby seize the following
Following
descriptive items
In connection
in
with
the reference on being produced
by from the
by from
possession,
the possession of Gautam Boro.
in presence of the below signed witness. My lord, at 2 feet, what prevented him from going there, my lord, and seizing this, my lord, weapon, my lord, whatever, my lord.
It was carried by him.
My lord, but you see, my lord, the description of the seizure, my lord, a 2 feet long bamboo,
Yes,
no blood stain, my lord.
that is a different submission.
Yes, ma'am.
You said that he did not seize from the place of occurrence. It was never there in the place of
Because
occurrence.
if there is so much of blood, my lord, everything they're wearing apparel, the bedsheet, that will full with blood, my lord. And there is no whisper to that effect. Even that has not been sent for serum test, my lord. He has admitted in his evidence.
No, is serological test necessary? How? Why is it necessary for
Beyond-
the blood? If
If
there
there
were
is,
stains on
if there is
the
no blood, he says, physically says no blood. So, my lord, all the evidences are not that trustworthy, my lord. If they say that they have seen with blood oozing out from the body of the deceased man. And lordship may say the this scissor witness, my lord, lordship will find number 1, Tomar Nursery, same place. Number 2, page 58, Titan Boro and Jogeshwar Boro. Lordship may see the sketch map, next page, my lord. Sketch map is the house of Gautam Boro. There, only B, house of Rajan Boro towards north, my lord. And bamboo plantation south and Gautam Boro's bamboo grove tree plant, nothing else, my lord, in the vicinity. Lordship, I may come to page 18, evidence of IO. Lordship, on 5-3, this is important. 21, I was posted as in charge of Gandhibari Police Outpost under Tamalpur PS on that day. Lordship, on that day means on 5th. At around 6 p.m., villagers of Uttar Golebara village informed me over telephone that Ritu Ramchari murdered Jogenboro. Accordingly, I entered the said telephonic information by GD numbers so and so. Customer kindly see.
Yes.
In the opening lines, he has stated, I was posted on that day, that was on 5th, I received the information for the first time. And I accompanied my staff, proceeded, and this GD entry is not exhibited, my lord. And I accompanied by my staff, proceeded to the place of occurrence, also telephonically informed SDPO officer in charge of Tamulpur regarding the occurrence. I found dead body of Jogenboro on the bed inside the house. He was lying in a pool of blood, my lord. On the bed, my lord. That means the bedsheet will also be full with blood, with injury on his face and mouth. I found daughter-in-law of the deceased and neighboring people there. I recorded their statement. I also brought the dead body to the police outpost with the help of police van. As it was night, so on the next morning, the inquest on the body was held by so-and-so in my presence. Thereafter, dead body was sent to so-and-so. I also drew sketch map of the place of occurrence at the time of my visit. I also brought the accused so-and-so, which is adjacent to Uttar Golebara village. The villagers apprehended the accused. After arrest, the accused was forwarded to so-and-so. On 4/1, Gautam Bora, son of the deceased, lost. On 4, says that on 4 he has lost as a my lord. The issue, and I forwarded the same to the Tamulpur PS for registering. Accordingly, so-and-so registered. I also formally entered to investigate it. I also seized one bamboo post cut out of bamboo piece stained with blood. Very important. From inside the house where the occurrence had taken place. Assuming for the sake of argument, if it is believe that he has committed the offense, then no one will leave the weapon, my lord, there, my lord. And on moreover, my lord, other witness say running away with a lathi, my lord, majorly contradicting. Exhibit 4 is the scissor list. Exhibit 4 is my signature. Exhibit 5 rough case not to scale of the place of signature is the inquest report. Signature of so-and-so. Cross part important, my lord. In the scissor list, it is not mentioned that the seized bamboo piece was stained with blood. Admitted. Such type of seized bamboo piece may be available in the household of every villager. In GD number 64 dated 4/3/21, I have mentioned the name of the informant who gave me the telephonic information, but I have not mentioned his mobile number. But in chief says he received it on 5/3, my lord. I did not see any
No, it
cloth
was
soaked.
not said on 5/3. 5/3, he says that he was
On that
posted.
day, villagers informed me over phone.
No, on
Lost
5/3, he
in my
was
opening
posted
line.
as in charge.
Yes.
The incident had happened on 4/3. When was the FIR lodged?
Lordship may see FIR was lodged on 4/3, that page I am seeing. Page 1, my lord. Time is there. 11
It
p.m.
was
night.
11 p.m.
Yes, my lord.
So till 11 p.m. there was no movement. So he talks about on 5/3 while he was posted in charge. Then he had gone for the after receipt of the GD
Then
entry.
how can 4/3 be the FIR, man? Because 5/3 he has received the information.
5/3 he states that on 5/3 he was posted. Incident is not of 5/3. Incident is of
No,
4/3.
Lordship, second line, page
Yes.
18. On that day at around 6 p.m. On that day means 5/3.
How can you say on that date means 5/3?
The first line is on 5/3. I was posted in charge. Then he should have categorically explained it in the chief, not in cross. On that day, it will be understood on that day, 5/3.
5/3 he says that he was posted because 5/3 he's made all the endeavors of going to the place of occurrence.
That is not clear, my lord. Even then, second prayer of cross, my lord. I have not mentioned his mobile number. I did not seize any clothes soaked with blood from inside the house where the occurrence had taken place. I also did not find any blood stain on the wearing appearance. How can that be? Chief is saying and cross some reverse. I also did not find any blood 10 on the wearing appeals of Ritu downstairs. I did not send the seized bamboo piece to FSL for serology test or fingerprint test. Very important. Because cardinal principle of criminal liability, my lord, beyond all reasonable doubt. Even a shadow of doubt comes in, then I am entitled to acquittal, my lord. As per Exhibit 5, sketch map, there is only one house of Rajan Boro nearby the place of occurrence, and rest place is a vacant land. I did not record the statement of Rajan Boro. Why? And his family members, beyond understanding. Rajan Boro was also not made witness in Exhibit 4. Very crucial. The seized bamboo piece was shown to me by Gautam Boro. It is not a fact he is shown in. So definitely question of prejudice will come. It is not a fact that I did not properly investigate the case and wrongly submitted the charge sheet. So suggestion was that you have wrongly submitted the charge sheet. My lord, this 30-30 statement, it's a case of denial, my lord. Only thing he said here, assaulted with a bamboo piece. Only stated I was not in a conscious state. My lord, so my lord, let us come to the judgment, my lord. But,
Question number 1, answer.
yes, my lord. But thing is that this is not an evidence, my lord.
We understand, but what is this answer? You
Because
said
what I-
denial, is it a denial?
Lordship, huh?
You said it's a denial of in 313. Yes, I assaulted.
Even if it is, your lordship takes this statement in his face value, my lord. But thing is that he said with the bamboo piece, whether it is sufficient to cause death.
It was a small bamboo piece.
Because
not-
allegation is a bamboo, big
Right.
like structure, and forensic report also says whether it is still sufficient to cause it. And it may be a case that his sister's husband was there, and his cannot be role cannot be. It may be a case that he has taken his culpability on his head, my lord. Because to that extent there cannot be anomalous, man. And there is an every attempt to make him a scapegoat, my lord. Judgment portion, paragraph 15, page 31. During her cross-examination, she stated that her father-in-law uttered abusive language to the accused, for which he was provoked. She again stated her father-in-law did not utter any word, and her elder brother, due to provocation, assaulted him. This is incorrect, my lord. And no finding is there. So what happened, my lord? Page 11, my lord. What he exactly said? Page 11, cross part. The accused is my elder brother. My elder brother used to scold my father-in-law harshly. Why he will do so and also get enraged? Letter says my father-in-law
Why he'll
said,
do so? Putting the question here will not help you.
my lord, not
Why he has
believable.
done that is not
Not
easy to look
believable.
out.
my lord. Had it been so, my lord, then
That
it
is
should
the
not be,
evidence on record.
should not be there on the, because
Why
this,
he has done, why he has not done, why, how can we know?
but this is not correct, my lord. What is
Why?
finding?
Finding we are not, we are as an appellate court, we are looking into the original materials. We are not too much inclined by the
Lordship,
judgment.
may kindly see page 16 also. I am coming to the
16.
page, paragraph 16 of page 31 of the judgment.
Yes.
PW3, my lord, on the fateful evening, Gautam Bora also deposed before students about 6 months back. The occurrence took place, he has mentioned the 4/3/2001, but he has not stated, my lord, in his evidence. The occurrence took place at the evening time on this fateful, he was in the house of one villager. One villager, who is the villager not named, my lord? Because he says nearby. His wife PW informed him over phone that her elder brother assaulted on the head and face Joganbhog with a piece of bholuka. Bholuka has explained a kind of heavy and big bamboo. That is not there in the scissor. Getting the information of the occurrence from his wife, he immediately arrived home so and so, so and so. Later on, PW4, my lord. Page, next page, page 32, para 18. He also said, he has stated Lathi, my lord. But learned code below, we also will find 8, 9, the PW2 and saw the accused running with a piece of bamboo. He never stated piece of bamboo in his evidence. He stated Lathi. So these are all not correct. Thereafter, my lord, page 33, para 20. PW6 IO inter alia stated that on 5/3/21 at around 6 p.m. he was in charge of, so he received the telephonic information. Here it is clear, my lord. Traffic query. From the villagers of Attar Golpar village to the effect that received water. Accordingly, he entered the said information in DD number so. After giving telephonic information as to an interest Tampur about the occurrence, he accompanied so place of occurrence and found dead body Jogan in a pool of blood on his bed. Again, he noticed injuries to mouth of his reported so. He also sees one bamboo. My lord, PW6 okay. So Lordship will find PW5 is missing. PW4 paragraph 18, PW4, then comes PW6, then come again PW5. PW6, no, any generally question.
5 has been said, paragraph 19, 4 and 5, both have been mentioned. 19, paragraph 19.
But what actually paragraph PW5 stated, that should have been there as discussed in other evidences. My lord. Paragraph 22, my lord, page 34. During cross-examination, he replied that he did not see any clothes soaked with blood from the inside the house. He also did not see the steel bamboo piece of.
5 has been mentioned in 26, 27, 28.
My lord, I am in page 34 of the judgment, paragraph 22, my lord. Page 34 of the
Don't
paper
go to
book.
the
sorry.
judgment, Mr. Bakshi, you make out your own submission, you have the materials on
Ma-
record.
What I am saying, my lord, is on the findings are not correct by the court below. Full with discrepancies, my lord, as I have showed, my lord.
You need not go to the judgment. You show us that with these materials, a conviction, finding of conviction cannot be arrived at. You make that submission and support your submission. We have seen the materials, we have seen 313.
My lord, paragraph 34, one last thing. Paragraph 34, the state GT has not been exhibited by the prosecution. Page 39 of the paper book, paragraph 34, my lord. And all of a sudden, the learned court will jump to a conclusion that he has paragraph 33, my lord, one last thing, my lord. PW6, paragraph 32 of the judgment, on the basis of which the learned court below has convicted, my lord. PW6 teaser list has not mentioned in exhibit. PW6 has not mentioned in exhibit 4 teaser list that the seized bamboo piece was stained with blood. He also did not seize the bamboo piece FSL to serology. But in my considered non-sending of the seized bamboo does not create any doubt on the prosecution case, neither state stating. So, my lord, how can that be, my lord? Because each and every, because in every criminal offense, my lord, there has to be a motive, my lord. What is the motive, my lord? My lord, may kindly say, whether a single witness whispered that this is the reason, it may be out of the heat of the moment, it may be previous rivalry, it may be any pending cases, nothing sort of there, my lord. And also, my lord, the seizure list is highly doubtful, my lord. Highly doubtful, and that too, with a weapon and a learned court below evidence case trace that it is a heavy, big bamboo, my lord. So had it been that and with hit with that object, my lord, that would have been because a lathi, my lord. This is lathi, my lord. So I pray, my lord, so already, my lord, sufficient 3 years, my lord, is behind bars. Also, my lord,
5 feet, 5 feet,
no, 3 feet. It's at
3 feet.
kindly come to
2
2 feet, even
2 feet.
smaller. So that is establishment. Because in criminal law, my lord, even a small doubt whether he may be innocent, my
Not
lord.
fanciful doubts, not lingering suspicion. Gone are those days.
But-
The smallest of doubts, lingering suspicion, it should be a
But-
reasonable doubt.
We-
What has been said in the Colonel Singh? That even letting
Beyond
one
reasonable
guilty
doubt,
escape is
because
also
to
not
arrive
doing
at a,
justice.
to arrive
letting-
at a
letting
conviction,
in the-
each
in-
and every evidence should say, yes, guilt.
No, in the context of letting 100 guilty escape, then to punish a innocent,
They are on that list.
even letting a guilty escape is not doing justice in accordance with law. That is the expression used by the Honorable Supreme Court, not once, many times.
In criminal law.
Yes. Not fanciful doubts, not lingering suspicion. Everywhere there will be a doubt. Whether the doubt is a reasonable doubt, which appeals to a reasonable mind, a
In my
prudent
case,
mind.
that is not a reasonable doubt because motive is not there. Weapon is missing.
There are case laws, Mr. Bakshi, that motive is not an essential part. And here, why should the own sister depose against the brother? She's an eyewitness. What is your submission so far as the eyewitness is concerned? What is your cross-examination?
Because he did not see the occurrence, my lord. As
She-
per the
She said
FIR,
FIR is not lodged by her.
let us see her evidence.
FIR is
my
not
lord.
lodged by her.
Let us see her evidence, my lord.
I witnessed the assault.
The accused came and entered the house of my father and assaulted him with his bamboo stick.
And what is the cross-examination? The accused is my own elder brother. My elder brother used to scold my father-in-law harshly and also got enraged. There's nothing you have said, done to demolish her evidence. Why should she speak against her own brother?
My lord, there may be, I admit that there maybe some hitting or whatever, my lord. And that is with my submission, that is, that as Caesar Lee says, with a stick, and this Eddie is also saying with a stick, whether it is sufficient to cause death. And that too, when all the evidence, everyone is saying that with a big holoka bamboo kind of thing, 2 feet stick, my lord, and they saying blood is there, everything is wearing, and cross, everyone turns, U-turn saying that it has not been, no such blood has been, nothing has been seized, my lord. Blood stained clothes, my lord. There were every, like,
Mr. Bakshi, see the wound's position and character at page 47. Please read.
page 47.
Yes. PM
Which-
report.
Postmortem. Name, date and page for external appearance, condition of subject.
Wounds.
Wounds.
Wounds position.
Lacerated
character.
injuries to and so.
Lacerated injury over upper lip, 3 cm, 1.5, 1 cm. Lacerated injury over forehead, 10 cm.
That is there,
Into
my lord.
4
But
cm.
my lord, whether he is, I am the one who inflicted the injury of such a nature. That is not in the evidence.
Witness, eyewitness.
No, my lord, eyewitness is full with doubt, my lord.
What is the doubt? Where is the
Because-
cross-examination?
Because Caesar list, nothing, Caesar list says everything, my lord.
Caesar
I
is-
admit that there might be a blow, my lord, but that is not sufficient to cause death, my
What
lord.
is your cross-examination in the eyewitness?
Huh? IO.
Eyewitness, PW2.
That is there, but lordship only on.
Mr. Bakshi, you are an amicus curiae. You are trying to assist the court. Be fair to the court.
Whether in cross
Your
examination,
duty is not to say anything and everything, it is to defend.
because
Yours is to defend as well as to assist the court. Why have you appointed you as amicus?
to assist court.
To assist the court. You are the friend of the court. Your duty is to place
But-
everything fairly. You show us how PW two has been demolished.
PW to demolish to the extent that he has stated stick is there, it's a stick. And in the cross part, what the learned council below tried to establish is the motive. That is also under question mark, my lord. I am saying that yes, there might be a hit with a stick, my lord, but not fatal to cause death, my lord.
That
And
is
even
why-
he
that
was
is-
not taken
that
to
is why-
hospital.
That is where we asked you to read the injuries part.
Yes, my lord.
What is the injury? Let us for the time being assume that it is a small stick. What is the nature of the injury?
It might be a case where someone else might have given a blow, my lord. It may be, my lord.
The own sister will say something else.
His husband may and his brother, her brother may take the responsibility.
Where is the foundation? Is there any foundation in your cross-examination?
So,
See the injuries, lacerated injury on forehead,
Hmm.
10 cm, 4 cm into deep into bone. Lacerated into 10 cm, 5 cm into the deep into the left eye. Left eye is completely damaged.
but my lord, doctor's evidence says that this kind of injuries may be due to a fall, my lord. Also, he had been, if he had taken to hospital immediately, he would have survived, my lord.
No,
And
not he would have survived.
Yes,
It's a
PW1,
general
my
statement,
lord.
Mr. Bakshi. Please,
PW1,
please do not add.
PW1 cross part, my lord.
Please do not add.
Please kindly, I am not adding anything, my lord.
Please do not add. We have read
Page
it.
9, my lord, page
Yes,
9
yes.
of paper book, my lord.
Please come.
Page 9 of paper book, my
Yes,
lord.
yes, please come.
Skull and scalp were found
Yes,
healthy at the
yes.
time of PMS. Such
Yes.
injuries may be possible by falling on hard surface. Apart from the aforesaid injuries, I do not.
See the last line. If proper and adequate treatment is given instantly, immediately after injury, the victim may survive, but not always. It's a very general statement. We have read this.
But why he was not taken to hospital, that is a mystery. And that too, 5-3, he has said that he received information for filing of FIR. All these minor are not minor contradictions with all respect. Lest I leave your
Is
lordship.
it one blow?
Huh?
Is it one blow? Is it one blow?
Regarding blow, nothing has come.
No, from the wounds, from the injuries. It is not one blow.
Yes. That is what I am saying. Because
Repeated.
witnesses ran with a lathi and that he said that it is there, it full with blood. Who has caused the injuries? Who inflicted the injuries, my lord? That is a question mark. I may not be there also. There is all likelihood, my lord. There is solid evidence is not there, my lord.
Mr. Bakshi, we can accept even for the purpose of examination or consideration. Where is your foundation? 313, you said you assaulted. You may immediately say 313 is not evidence. We know, but it will be used for corroboration.
But assaulted, but my lord,
You should have said I was not there.
I see. That is the line where I am, lordship has rightly said that the
You
first,
are not there.
but with a stick, my lord. With a stick.
There is no
It may
other-
be a case some other could have given a blow. And that is there, my lord. That is I am saying, my lord. With a stick, it might be, my lord. Because the 13,
hitting me on the head and face. I was not in a conscious state. Yes, villagers apprehended me while I was running away from the house of Jogen Boro.
Notice case map is also doubtful. So many people, public apprehending him. No houses there, my lord. Only one house. And with this informant where he was in Sato ceremony, not a single of them has been examined, my lord. Whether he was there in the Sato ceremony or in fact they are hiding or somewhere doing something, my lord, that is also. Because if that is so much of truth is there, my lord, it will be, I would have examined those persons, my lord. His presence in the Sato.
So it will be an unending process.
Yes.
Why not 2? Why not 3?
Because
Why not all the-
non-examination
why not
of
all the village?
non-examination of vital,
How
at
many?
least 2-3 of them.
How many? Is it
At
the,
least the landlord. at least
Is it the quantity or quality?
at least one of them, my lord, that
Why
is the
one?
quality.
Why not
Whether,
two?
whether he was there in your Shraddha ceremony.
If there would be one, then
the
you say
plea
why
of
not
alibi-
two? Why not
alibi-
three? It is
Yes,
not,
ma'am.
it is not the quantity.
Plea
Yes,
of
madam.
ali-
Anything else? Any decision?
No, no. A one is there, my lord,
Yes.
regarding this defective investigation. And in this case, the seizure list was also not there.
Citation,
Evidence on evidence is
citation, citation.
2013 12 STC.
2013,
ATDO,
12 SCC.
page 349.
Name,
2013 12 STC.
name. Name of the case.
Vyas Ram, alias Vyas Kumar and others versus State of Bihar.
Which para?
I am relying on para 31 to 34.
Regarding?
Regarding, because my lord, evidence on record carefully re-examine and conviction of only those, my lord, regarding defective investigation, my lord, and contradiction of witnesses. Similar to this case, my lord, little bit.
Yes, madam.
May please the Lord. In fact, what it has fallen from your lordship thoughts. PW2 statement is not demolished in any manner. PW2 is very consistent in saying he was there in the house, father-in-law was sleeping, he came, the accused came inside the house, then entered the house, assaulted the father with bamboo lathi. Bamboo lathi, she speaks of a stick. It's not that he was injured by a machete. It's a stick and it's a bamboo bah or whatever. She said stick and it is a bamboo. There's not a lot of difference there. Had it been a gunshot, had it been a dowel, stick, dowels used in the offense, then the matter would have been different. Here, stick.
No, she said bamboo stick.
Bamboo stick.
Bamboo stick.
Both.
Bamboo.
Bamboo stick.
Bamboo
Bamboo
is-
is also there. Holuka Ba. And then she said, I witnessed the assault in so many words. Then she shouted. Then the villagers came. And then police, the villagers apprehended. Police came. They handed over to them, to the police. Then her brother came. She told her brother. Then her husband came.
Husband.
She told her husband. She was so precise in saying each and every line. I mean, there is no demolition at all in her cross-examination. Cross-examination, she said, accused is my own elder brother. Elder brother used to scold my father-in-law harshly and get enraged. My father-in-law did not say anything. My elder brother assaulted him out of anger. And I've checked her 161 statement also, similar line. She said to the police, her brother came, they were speaking with each other. Only difference is that what she said, she used to come in a regular basis to her house and speak with her father-in-law. That day also he came, they were talking with each other and thereafter they started fighting and then she heard a sound and she came out and then she saw him hitting. She said in her 161 statement, and Lordship knows single eyewitnesses is enough to bring home the guilt. Now here, there are corroborations also. PW4, the husband, he said, of course he did not say in the FIR, and FIR is not an encyclopedia. He said in his statement before the trial court, when he came back, his wife informed him over telephone. He came back, he saw his father lying on a pool of blood and his head and face was smeared. He supported the PW2. And then he also said it was hit by a bamboo and they were in a Shraddha ceremony. Police came. Police took this bamboo stick. He had put his signature. He also said, I did not witness. It is not a fact. I have stated falsely. My wife had not told me. So even in cross-examination, nothing is demolished. 5 and 6. In fact, 161 statement I have seen of 5 and 6, they are the eyewitness. They had said that we had witnessed the beating up also, that beating part. But in their trial statement, they did not. They had said only about running away. They saw him running away with lathi. It's not simple running away. With Lathi, they saw him running away from the house of Jogen Boro. And thereafter, they apprehended him and they handed him over to the police. And in the cross-examination also 4, nothing. He reiterated that he saw Ritu Ramchari was running away. PW4, I saw Ritu Ramchari was running away from his house at the time of occurrence. These are all corroborations to the eyewitnesses. These are all corroborations. It is not a fact I did not see Ritu Ramchari fleeing away from the house. Then 5 also is consistent. He also said, I saw Ritu Ramchari fleeing away with a lathi on his hand. After entering into the house, we saw his head and face smashed. In fact, the injury also tallies. The injuries were on the left eye, on the forehead, and then the eyewitnesses also said that he was hit on the head and the face. So all things tallies. There are no scope for someone else coming in between. Then police, of course, what he had tried to say that the FIR was not lodged on that day. FIR was lodged on 4th of March, as I can say. GD entry, I have checked. It was on 4th of March. It was in the afternoon. GD entry was entered at 7:30, 8:30, Rati 8:30, 8:10 Bozar. GD entry was made. And then the FIR was lodged at 11 p.m. Few hours after that. So this is not a case also that GD entry will become the FIR, because within 2 hours the FIR was lodged that the investigation started. So there is nothing, and there is no contradiction as far as PW2 is concerned in the statement of the IO. There is no contradiction at all. And his admission in his 313 statement. That 313 statement has to be considered while delivering the judgment. And he had categorically answered, yes, I assaulted Jogen Boro with a bamboo piece, hitting him on his head and face. Yes, villagers apprehended me while I was running away from the house of the Jogen Boro. Rest, he of course, he said that I do not know. And in his sentence hearing also, he said that I am innocent and I did not commit murder of Jogen Boro. Murder, but then hitting part he had admitted. I had hit him on his head and face. Maybe he did not have intention to kill him, but then it happened at the spur of the moment. And injuries were on the head, left eye, and 10 centimeter lacerated injuries, cut wound. Quite a big one. So, and the sketch map, of course, the police said that other houses I have not shown in the sketch map. I have drawn only one house of Rajan Boro. Or Gautam Boro, no. Gautam Boro. No, Gautam Boro is where the place of occurrence. This is name Gautam Boro, no. Okay. His name is, no, Jogen Boro. Jogen Boro. And I think his name is Gautam, no? PW3. Yes, PW3's house is shown as the place of occurrence, and only Rajan Boro's house is shown. And police in his statement had said that I have not shown other houses in the vicinity. That sentence, I got it somewhere. He had said,
Gautam, informant is the son.
Son. That is his own house. I did not record Rajan Boro, Bamboo Piece. No, somewhere he said that other houses, as per Exhibit 5 sketch map, there is only one house of Rajan Boro nearby the house of occurrence, and rest of the place is a vacant land. So those houses are little away from the house of Gautam Boro. So in my humble submission, nothing much to add rather. This statement of PW2 inspires confidence. And since a single eyewitness would be enough, so her statement is enough to bring home the guilt, and coupled with the corroboration from 4, 5, and 6, and the doctor's evidence. That also tallies with the evidence of PW. In support of my statement, I would just like to give 3 judgments. One is that one eyewitnesses would be enough. One eyewitnesses is enough, that is Kartik Malhar versus State of Bihar. Their lordship will see paragraph 11, 12 and 13.
Give this.
This is 96 1 SCC. Six one four. 96 1 SCC 614.
Para?
Paragraph 11, 12 and 13. Here it is said even corroboration is not required, but in case lordship thinks that in the facts and circumstances something is required, then lordship can go into. 11, lordship, I've taken out the yes. 11, we have already discussed above that it is open to the courts to record a conviction on the basis of the statement of a single witness, provided the evidence of that witness is reliable, unshaken, and consistent with the case of the prosecution. The case of prosecution cannot be discarded merely on the ground that it was sought to be proved by only one eyewitness, nor can it be insisted that corroboration of the statement of that witness was necessary by other eyewitnesses. In the instant case, it may be pointed out, does not strictly fall within the category of those cases where only one witness is present and the case of the prosecution is thought to be proved by the statement of so-and-so. Lordship can skip over that. Here again, the Honorable Supreme Court has observed the findings and conclusions in Vadivelu's case, where there are no exceptional regions operating. It becomes the duty of the court to convict if it is satisfied that the testimony of a single witness is entirely reliable. We have therefore no reasons to refuse to act upon the testimony of the first witness. Then paragraph 12, as to the contention raised on behalf of the appellant that the witness was the widow of the deceased and was therefore highly interested and her statement be disregarded, we may observe that the close relative who is a natural witness cannot be regarded as an interested witness. The term interested postulates that a witness must have some direct interest in having the accused somehow or other convicted for some animus or some reason. Now, here my learned friend has said the actual offense was committed. It can be a case that actual offense is committed by the husband, but then the brother took all the responsibility. But there has to be something on record, at least before the police, or at least something that can be a possibility. But there is nothing on record. How can we bring that fact into record? It's very difficult. Moreover, a close relative who is a very natural witness cannot be regarded as an interested witness. The term interested postulates that the person concerned must have some direct interest in seeing that the accused person is somehow or the other convicted, either because he had some animus with the accused or some other reason. In Dalit Singh, a witness is normally considered independent. Lordship need not go into that. And then 13 is also that eyewitness being a solitary eyewitness and a close relative. This is all. So the fact remains a single witness would be enough. The second decision is on no motive. No motive is required in case of eyewitnesses. This is Chandran versus State of Delhi. This, I could not get the SCC citation. It is there. It is Supreme Court decision. It is 2024 3 Supreme 516. This is paragraph 5. The argument, Lordship got it?
Yes, yes.
The argument of the defense that the prosecution has not been able to establish any motive of the accused for committing this dastardly act is in fact true. But since this is a case of eyewitness, where there is nothing to discredit the eyewitness, the motive itself is of little relevance. It would be necessary to mention some of the leading cases on this aspect. Lordship has gone into this 73 Supreme Court. It was held that it is a well-settled principle in criminal jurisprudence that when ocular testimony inspires the confidence of the court, the prosecution is not required to establish motive. Mere absence of motive would not impinge the testimony of a reliable eyewitness. Motive is an important factor for consideration in a case of circumstantial evidence. But where there is direct eyewitness, motive is not significant. That is what it was held. In case the prosecution is not able to discover any impelling motive that could not reflect upon the credibility of the witness proved to be an reliable eyewitness, evidence as to the motive would no doubt go a long way in cases wholly dependent on circumstantial evidence. Such evidence would form one of the links in the chain of circumstances in the case, but that would not be in In cases where eyewitnesses of credibility, though even if such cases is a motive, if a motive is properly proved, such proof would strengthen the prosecution case and fortify the court in its ultimate conclusion. But that does not mean that if motive is not established, the evidence of eyewitnesses is rendered untrustworthy. So motive, what my learned friend was saying, will not be necessary in the instant case. And the last case, Lordship will see this 2009-6450. This is on res gesta. Res gesta, why I'm bringing up
2009,
6 SCC 450.
name,
Name is Lordship. I got to download.
Javed Alam,
Paragraph 9.
Javed Alam.
Acha, yeah. 2009 6 SCC. The download. Pages 450. This is paragraph 9. This is on the evidence given by 5 and 6 that they saw him running
Almost part of the same transaction.
part of the same
In one of
transaction.
the recent judgments, we have elaborately discussed all the case laws on register.
Oh, yes, that is there. And this is also there, a small paragraph.
PW, which two PWs? 4 and 5.
5 and 6. 4 is the husband.
No,
5
also-
and 6 will be.
Also saw running away.
4 also saw running away. 4. And 3, 4, 5. Yes.
4 and 5.
4 and 5.
4 and
Informant did not see running away. 4 and 5.
4 and
This
5,
is
4
for
and 5.
the res gesta part. And the Caesar list, as he had said, no FSL and all that they also have submitted one Justice Ujjwal Bhuiya's judgment that
Yes.
non-sending for FSL is not for fatal always. And in a case of eyewitness, it is not required. This is my humble thought.
One last thing I would like to add, my lord. The incidents took place on the fateful day at around 5:30 p.m., my lord. And his informant was informed he came back at 6 p.m., my lord. And FIR was lost at 11 p.m. on that day. So there are a whole lot of 5 hours, my lord, in between. And it is not a case that someone has come, has stood somebody, my lord. We don't know what for he has stood. In that case, my lord, encyclopedia is not a fact that is the argument is tenable. But if some economic offenses happens, my lord, you have to go to the deep into the thing, my lord. In that, but here in this case, my lord, 5 hours, my lord, an affair in the affair, nothing has been spelled out with regard to eyewitness, my lord. And can it be believed that his memory remains fresh, my lord, at that point of time? There is a delay of 5 hours in between. He could all the facts he could be known to him. My wife might have been immediately reporting as to what happened, my lord. There, if it is a fact that immediately incident happened 5:30, you have lost the affair 6, my lord. Someone has killed someone, we don't know. Some outsiders came, stranger came. That way it can be believed. But here, 5 hours delay in FIR, my lord, not naming the eyewitness, seriously cast doubt, my lord. It is the eyewitness is not at all believable in my respectful submission.
In fact, that I'd just like to add here, page number 11, there's something which the office could not translate, that some part is illegible of the eyewitness. Lordship had seen page number 11. I have checked from the original record, it is written Jokham Hoy. Yeah, my father-in-law sustained injury on his head and face. Thereafter, the Assamese part is Jokham Hoy. He is injured. That could not be translated and written. But then it's very simple. I mean, it's legible.
He died immediately.
He died immediately. This dotted part are Jokham Hoy.
Okay.
There are injuries.
উঠিব লাগিব এনে বেলেগ বেঞ্চ আছে ন মাতি দিব লাগিব এওঁ মাতা মানে এওঁ মাতিছে ন ডিকে বাকচি এণ্ড এজ জাহাজ হা হিয়াৰিং ইজ কনক্লুডেড জাজমেন্ট ইজ ৰেডি বিনয় দেখাই আছে বিনয় আহি বহি আছে দেখা নাই মই তেওঁক নামাতা বুলি Okay, we'll consider.
Right.
Milord, item number 11, Milord, can it be on Friday?
Friday, don't put anything on Friday.
On Tuesday, Milord,
Huh?
on Tuesday, next Tuesday, Milord.
Next Tuesday, we can try. Next Tuesday, okay. Yes,
Yep, yep.
single bench will sit at 3 o'clock. Oh, division bench. Oh. Oh.
This is your lordship. What?
It yet to be admitted or what?
Lordship, it was admitted, but there is one point aspect that has been, your lordship, pointed out, your lordship, by my learned friend, your lordship, Cornea, your lordship, that whether against the framing of charge appeal will be maintainable or not. Your lordship. That there is one judgment, just now I have gone through, your lordship, Dhoni Devi, your lordship. If division bench of our high court says that it will not be, appeal will not be maintainable.
That is it.
That judgment. If your lordship takes up this matter some other day, your lordship, I will go to,
No,
or
if the
otherwise,
division bench is held there, like that, why there should not be any other views?
Lord,
And otherwise, the framing of charge, whether it's an appealable, we ourselves we're in great doubt.
Lord, or so far as your lordship,
In fact, the full bench decision of this honorable court.
Full bench.
that is relating to your lordship, the
There has been a
slightly
discussion on-
different. But your lordship, this Londoni Devi is clearly on this issue, your lordship. And in fact,
No,
your
is there
lordship,
any further scope of deliberation? If there is no scope, then why should we?
Lord,
Un-
or your lordship may, your lordship can convert it to criminal revision also, your lord. Because your lordship, at the end of the day, when it will be converted, your lordship, as per the honorable apex court judgment, your lordship, it will be hard, will have to be heard by division bench, your lordship. That's the Kerala case, your lordship. I have that judgment, your lordship.
What do you say?
2021 SCC online, Supreme Court 3099.
No, but then in that case, since
You
Mr.
can withdraw this.
No.
liberty to
No, that part, that aspect we may take, we may make it easy for the, it's a question of convenience, not only convenience, interest of justice.
Lord,
We may not burden him of filing another revision. But what we are trying to say, Mr. Dev Chaudhary, that you have taken time to file an objection.
Yes.
I think it file an objection. In the meantime, the further course of action, since we are in the know of things,
Lord.
that how it will proceed, you can just think of how the best order is to be passed.
Lord,
Will this appeal as such will not be maintainable.
But
We'll hold that. And so far as bringing into record the two other judgments, including the one which will be that we can indicate to the registry of
Yeah.
converting and placing it before the appropriate bench as per
Lord,
the decision. But I think you file a small objection. Can you do it within 2 weeks?
2 weeks.
2 weeks, because this matter has been assigned, I think, to this bench.
Lord, Lord.
We'll have it after, we can fix, if you want, we can fix a date also. Or we'll have to after
Lord.
2 weeks. After 2 weeks, okay. Heard 3. 2 weeks. Heard 3 as Bothapur Learned Counsel for the appellant, as well as 3 R.K.D. Chaudhary. Learned. You act as special PP,
Lordship can record.
Special Public Prosecutor, NIA. Para. 3. The learned special PP has submitted that on the earlier occasion, a point was raised by him on the aspect of maintainability of an appeal against an order of framing of charges. Full stop. He has also submitted that on this point, though an objection was sought to be filed, the same has not been filed, for which he prays for some more time. He has also informed this court that there is a division bench judgment of this court wherein this point has been clarified. Full stop. Tara? Sri Bothapur, the learned counsel for the appellant, has fairly submitted that he is aware of the division bench judgment, and therefore the aspect of converting the appeal into a revision may arise.
Sure.
And he has also submitted that as per a decided case law of the Honorable Kerala High Court, such a revision can be filed and heard by a division bench. Full stop. Not now.
Lord.
Oh, okay.
Lord. Lord.
Considering the aforesaid submission, we direct the NI to file an objection indicating the aforesaid aspect within a period of 2 weeks
Lord.
from today. List after 2 weeks.
Lord.
You can provide
Then-
this until
then
next date.
It is not inconvenient for my facility of
20
26.
as paid for. List on 26/5/2020.
Safety of life. Last paragraph of the chart.
Interlocutory, the difference between interlocutory and intermediate
Lord.
has been explained. Okay, you can please on the next date.
Lord.
Huh? So item 2 will be the same order.
Not the same order.
Then both with